With my lord's permission, may I mention item 110? This is that PF matter, my lord.
Which is that?
That Provident Fund matter where the question of international workers, the learned single judges struck down that part of the scheme. I'm only mentioning because my lord had ordered me to mention it today because my lord had listed for final disposal today with the consent of the parties.
We'll take one.
Great. Great.
Serial number 5, my lord.
Fresh PIL matter. I moved this memo 2 days ago, my lord. Not the 14. Not present inconvenience for the dinner. I think the premium family. So in the file we had on 19th November.
My lord, serial number 5, my lord. PIL matter, my lord. I request matter may be taken up next week, my lord. The request, my lord. We engaged a senior counsel, is not available today. my lord.
20th.
Please,
My lord, serial number 53. Serial number 53, I am for the petitioner, my lord, that vacating stay application has been filed by the others. We need to some time to file the objection, my lord. Serial number 53.
53.
Yes, my
Read petition.
petitioner, I am for the petition.
So you on time,
Yes, my lord.
December. 10th December.
Interim order was there, my lord, maybe extended.
Interim order is there.
Please, my lord.
Then we'll give a short. 28th October, 28th November.
Please.
Serial number 66, my lord. Serial number 66, my lord, contempt matter. I'm withdrawing the matter, my lord, already. 6, my lord.
66.
All 6. Withdrawing the matter, my lord.
66.
Contempt was reviewed.
592, learned advocate, Mr. M.N. Madhusudan for the complainant. Else memo dated 7/11/24. Stating that he has instructions from the petitioner complainant to withdraw the contempt petition. The memo is taken on record.
My lord, serial number 54, my lords.
Dismissed as withdrawn.
Serial number
54, my lords.
Serial number 114, my lord.
114. 114.
Short adjournment, short.
Why?
You should file, they have filed 2 endorsements, my lord. They have filed 2 endorsements. We have compared the order, my lord. We are accused in this case. We have compared the order, my lord. We have also filed complaint of fidelity.
You are for respondent.
No, definitely. Respond-
Why do you seek?
They have filed 2 endorsements, my lord, in there.
So file it. No time.
Reply, my lord. We'll file reply for that endorsement.
Pardon?
We'll file reply, my lord.
What reply? You are the respondent or petitioner?
Respondent.
So why? You file it, let it be called. You are filing some endorsement to it.
No, man, they have filed, my lord. So that endorsement.
Let it be called out, no time.
My lord, serial number.
Pertains to cooperative society. My lord, the appellant is a was a director. My lord, he was impacted by a disqualification order by the joint register, my lord.
No urgency.
My lord, serial number 54, my lords, adjournments.
There's an election which is being conducted, my lord. He's been disqualified on that also, my lord. This is.
Will be listed in.
My lord, serial number 54, my. Serial number,
If we give date, it will be later. If you wait for regular listing, we earlier.
My lord, we have complied with the office of.
If the court gives a date of posting, it will be later. If you wait for your posting in regular court, it might be earlier. What do you want?
My lord, any moment the election. will
What
be
do you
conducted.
want now?
Any moment election will be conducted.
Maybe, but
In this week, 11th of.
that court will give the date.
There's an urgency, my lord.
my lord,
On the election matter, my lord.
So then wait, it will be listed within 5 days.
There's an urgency. my lord.
We don't perceive any urgency. Date can be given by 2nd December. Not earlier. Instead, you wait, remove the office and pursue with the office, we listed earlier. See that it is listed earlier. We are not giving. Yes.
my lord, serial number 54, my lord, seeking adjournments, my lords. Because,
50?
54, my lords. Senior close relative has been expired, my lords. So,
54.
Yes, my lords.
Why?
Let senior's close relative has been expired, my lords. He has been there, my lords.
There is a delay of 27 days, notice returnable on in IA. 11th. Notice already, then 11th December, as requested on behalf of the appellant.
Much of it.
Serial number 49, ma'am. 6 adjournment, my lord.
Serial number
49.
49.
Yes, my lord. Senior is hospitalized. ma'am. So, senior is hospitalized. Yes. So, 2 weeks time maybe.
12th December, at the request of learned advocate. For the appellant petition.
Item number 26, my lord, as personal intervene, I pay for the appellant.
26.
26.
So which date do you want?
Any date,
It is a company appeal, commercial appeal.
commercial.
26th November.
Serial number 48, my lord, appearing for the applicant. One of the parties has raised, we have to file initial application to the chamber. If a week's time may be granted, will be due.
48. 27th November.
Serial number 75, my lord. 75, serial number 75.
Serial number
Serial number 75.
7.
I am for appellant in this case. Your Honor.
7.
75.
75.
Kindly granted 1 week soon.
It is.
For the office complaints,
Office of.
that's why.
3 weeks time is granted to remove the. 3 weeks are granted.
Any mention through VC, sir? Kind permission. In contempt matters, seal number 1. Mr. Anish Jose Anthony.
Appear for the petition, my lords. But in this matter, my lords, on previous occasion, my lords has asked me to get a direction, to get an instruction whether the gold is been released, produced before the court or not. My lords, my instruction is that the gold is was not produced before the court. It was released by the police themselves, not subject to the correction of my learned friend. It was released by the police themselves to the de facto complainants immediately upon seizure. Thereafter, immediately within 3 days, they had filed charge sheet, and immediately upon the summons, the matter was referred to Lok Adalat for settling between the accused and the complainant. Because of the High Court order, my lord, the settlement couldn't taken place, and also the order is also not complied. The operative portion of the order is in page number 17, my lord, it's internal page 4 of the order passed by the learned single judge, paragraph number 4.
So it something is converted into what?
My lords,
What is the breach?
my lord, the order was that to restore the article seized from us within a period of 1 month. That they have not done that till
Who
date.
has not,
My lords,
who has not restored?
and the respondent police has to restore it. They are not restored it. But what was happening in all these cases is that, my lord, under the strength of 91 notice, they will seize the gold articles alleging that is involved in the crime, hand over to the de facto complainant. In the instance case, what happened is immediately after seizure, 3 days, charge sheet was filed. First date after issuing summons, the matter was referred to Lok Adalat. The matter will be settled between the parties. If the interim custody of the gold that has been handed over to the alleged de facto complainant made absolute and will be put nowhere. Considering all those circumstances, my lord, the learned single judge has passed an order that let the gold be restored to us after taking photographs, videographs, and preparing a proper panchanama. There are.
You are for.
Lord, I'm
For.
here in this case, what has happened?
You are for.
For the state, Lord.
State.
I'm AAG.
Yes, what is it?
Yes. In this case, not before the order was communicated,
gold, my lord, was released from the court to the victim.
To file that reply.
What?
File that reply.
Yes, my lord, I will find the reply. Not similar matters, my lord, from serial number 31,
Yes, it is.
32 and 33. It's a similar matter.
Similar matters one by one. The facts are little different.
Same set of facts.
Reply is filed.
Reply is filed.
Reply is filed.
And in 31, paragraph number 6 of their
Same reply. Pradeep CS. Chain snatching cases done. Chain snatching.
but in 31,
All, my lord, chain snatching cases, my lord.
no,
Wherein-
one by one will go, my lords. One by one, the facts are.
After snatching the chains, they had pledged it with this Manappuram's old company. But that has been recovered under PS.
In
And
the-
the court released it not towards the victim.
In the first,
It's in possession of the victim. In the meantime, Lord, the order of this honorable court comes that has to be released to them.
and in the first matter, it's not a case of chain snatching. The allegation is that the servant of the de facto complainant has committed some theft. Thereafter, my lord, within 5 days, it has been seized and recovered from us. 2 days, the interim custody has been handed over by under one. My instruction is that it's under 1023 by themselves. And immediately upon the release of the gold articles, which is seized from us to the de facto complainant, the charge sheet has been filed within 3 days. Immediately upon the filing of charge sheet, summons is issued, and the first day itself, my lord,
The articles are produced before the magistrate or not?
Yes, no.
Then
no.
there is no contempt.
no, my lord, that it's not produced.
It's produced before the under.
Let them-
has been produced. Charge sheet has been filed, CC number is there.
It is not produced, my lords.
But
Let
he
them
files
that
an
don't record, my
application.
lords.
Let it be
He
produced.
files an application, my lord.
Let it be produced and then you follow the file something and if it, as per the procedure, it will be returned to you, it will be done on
Yes.
condition.
My lord, let them put on record, my lord. It will produce before the magistrate. My instruction is that not produced. It is released under 1023.
Where them to, there is no contempt. We'll record the statement it is produced.
Grateful, my lords. In serial number 1, my lords.
Similar matters, my lord, say 31, 32 and 33.
31, my lords. But 31, my lord, they had filed the complaints about it in paragraph number 6, my lords. We are satisfied with that, my lord. In recording the statement in paragraph number 6, it may be closed, my lord. 31.
Yes. We are not pressing this.
31, my lord, they had stated that they are in the process of complying the order, my lord. We are satisfied in that. In paragraph number 6 of the complaints affidavit.
Or learned advocate Mr. So and so for the complainant and learned advocate Mr. Learned additional government advocate Mr. So and so. What is your good name?
I'm Pradeep CS, my lord, additional advocate general.
For this case for learned additional advocate general. So this Pradeep case for.
CS. CS.
PS for the respondent. Contempt of court is alleged by the petitioner complainant. In respect of the directions contained in order dated 19th April 2024 of learned single judge, passed in read petition number 10976 of 2024. In response to the notice paragraph, compliance affidavit is filed by the respondent. Paragraph 6 thereof reads as in the. It's left.
Investigation directed to
Blue
return
flip.
the article to the court.
In view of what is stated in paragraph 6 above, learned advocate for the complainant does not press the present petition. Dismissed accordingly.
But in serial number 32. But this is a case, my lord, this is a case of contempt, my lord, even by the record, my lord. I will demonstrate, my lord, in 1 minute, my lord.
Then you are withdrawing any other matter?
My lords?
You are withdrawing any other matter?
No, no, no.
Now come to this present one.
Serial number 1, my lords?
Now, Mr. Pradeep, you would like to file reply or will record a statement?
We have already filed a reply, my lord.
Serial number 1.
33 we have filed.
32, I'm sorry, my lord, 32 and 33 we have filed reply.
No, here will
we have
like,
Serial number 1 we have to file. My lord.
you would like to file or?
I will file.
These two
File
are taken
reply.
up along.
Learned additional advocate general who appears upon service of copy of the petition in advance would file reply as requested by him before the next date put up on 21st of November.
Obliged, my lord. The other two cases also may be posted on the same.
On same.
Serial number 32 and 33.
32 and 33.
Wait, my lords.
What's okay?
Serial number 2.
My lords, 32 and 33 subjoining, my lords.
Same date.
Great,
21st,
my lords.
Same date.
Great.
To be listed with.
Serial number 2, Mr. K.V. Narasimhan. Serial number 2. And the direction to dispose of the review petition, my lord, within a period of 3 weeks. Dispose, 31. 31 serial number.
So let's keep it. What is?
Direction to dispose of a review petition within a period of 3 weeks' time, my lord. I am telephonically informed that it has been done. I will secure the document and place it before the court, my lord. I'll secure the document and place it before the court. Direction is to dispose a review petition within a period of 3 weeks. That is the direction from the learned single judge, my lord. It has been complied, my lord, telephonic.
Statement that will dispose it of, we dispose it of.
230 lordship may have it, my lord.
I disposed.
That telephonically I will receive the information. I will
Right,
try to place the records, my lord, at 230.
Serial number 3, Srimati Shilpa Rani.
Notice returnable on 2nd December.
Serial number 4, Mr. Sampath.
Notice.
Please,
2nd December.
please.
Serial number 5, urgent. Serial number 6, PAL to J.R. Mohan.
Ready for petitioners, my lord.
My lord,
I've got a certificate, my lord, from the Gulbarga Electricity Supply Company, my lord, to say that their, my lord, grievance has been redressed. Completion certificate, my lord. My lord, I'll file it with a memo in the office.
Will say the prayer in the misconceived petition is redressed.
my lord,
Prayer in the misconceived public interest petition is redressed. Will say like that.
Lord, I'll file it with a memo in the office.
Learned additional advocate, additional government advocate, Ms. Neelofer Akhtar. Places on record. Work completion report dated 4/11/24. Issued by the Gulbarga Electricity Supply Company Limited. Which states that the work of electrifying the unelectrified households in SC/ST colony in Sawargaon village, Aurat Taluka, has been completed on 4/11/24. Learned advocate for the petitioner would submit that the completion of the said works amounts to satisfaction of the grievance, redressal of the grievance of the petition in this public interpretation. Dismissed as not surviving. Petition is dismissed as not surviving.
This number 7, NS but
This property belong to the temple, my lord. It has in the year 1961 itself, the Deputy Commissioner has reserved and it is a civic community site. The respondent of 7 to 9 unauthorizedly constructed the building. Hence, I have filed a complaint before the BBMP and BDA. They have passed 321 order, 323 order, and also 462 authorizing the assistant executive engineer to demolish the building. Even they have prepared the rough sketch also, estimate started, but abruptly stopped now. Kindly see the photograph I put and I said J1 to J. The original photo is J. It's a small temple. Now it is a big building is constructed.
Not is returnable on.
At least my status quo, still they are constructing in spite of,
So why static? You want to demolish?
they have to demolish, please. Please, there is a direction,
Demolish the structure.
please.
Then why?
Demolish not done, demolish not done, demolish just started. Abruptly they have stopped now.
Then you want status quo
Status,
without application of mine. In every case, you seek interim order,
No,
even if it is against. No, why, how can we be done? Notice it never done. 25th November.
much.
This seal number 8, the Kaushik BS.
Lots. Interim order is necessarily required in this matter and also in imperative nature. Lots. This is a fit case to exercise power confirmed under the Article 226, read with Article 13 of the Indian Constitution. My lords, the matter is, the facts of the case is, from T. Narsipura to Gopal Swami Temple, there is a road. The road is projected it as National Highway number 766. And they have projected it as an authorized National Highway toll. Number 1. My lords, while we entering to the toll plaza, there are the two toll plazas. Number 1 is KNOD, number 2 is Eddora FP. While entering to the toll plaza, there is no provision of service road or bypass road or any village connecting road. It is a small road or a big road. There is no thick road is provision neighbor to the national highway, said national highway, and there is no alternative road. Hence, on an inevitable condition, we have to by making a payment of the fee. My lords, here is the payment of making a payment of fee is a fee word is a vital role in this matter. What is fee and what is tax? The tax is, my lords, while as making a payment of tax, we cannot while we're making a payment of tax, there is no direct give and take or cannot demand for special favor from the authority. That too in a benefit of individual. While making a payment of fee, there must be a special favor from the authority to the benefit of individual. Number 1. Here I'm going to assist your lordship to veracity of number 1, infringement of fundamental right. Number 2 here is the said NHA road is an unauthorized. By unauthorized toll plaza, they are collecting the fee from the public. While we enter into the toll plaza, my lords, there is no such other alternative road. It is clear infringement of fundamental right confirmed under Article 19 class 1 class D and Article 21.
21.
Here.
Right to pass through toll plaza.
My lord?
What is it, 21? Right to pass through toll plaza with convenience.
Article 19 only, my lords. And also Article 21. I will rely upon the court judgment, my lords.
Cyril. But you tell us amongst two of you who is more senior?
My lords?
Amongst two of you who is more senior?
Both are colleagues.
You appear to be senior.
Yes, sir.
The same age.
Same age, same colleagues. One day college al
Same day.
Yes.
Started.
Yes, sir. Lords, kindly may come to page in the case of NB Kare petitioner versus State of Delhi. Para number 20, my lords. My lords, NB Kare petitioner versus State of Delhi. Kindly may peruse page number, sorry, para number 20, my lords. May I read the para number? The contention of the petitioner here that restrictive provisions mentioned above under which a person could be removed from the particular area or prohibited from the returning inconsistent with the fundamental right guaranteed under Article 19 class 1 class D of the Constitution, under which all citizens shall have a right to move freely throughout the territory of India. This right intended is not absolute and extent to which could be curtailed by legislation is laid on clause 5 of the Article 19, which run as follows. Nothing subclass D, E, and F of the said clause shall affect the operation of any existing law in so far as imposes or prevent the state from making any law imposing reasonable restrictions on the exercise of any such right confirmed under the subclass, either in the interest of general public, my lords, and general publics, or for the protection of the interest of any scheduled tribe. Here is the parallel to the National Highway Road, irrespective of scheduled caste, Gaudas, Vakali class, all our publics are residing. All public, irrespective of caste, are residing, number one. And also general public.
Public has no caste.
My lords?
Public has no caste. Why are you mentioning caste?
Caste.
You are saying that.
My lord, continuation here is.
You are mentioning that these castes are residing.
Yes.
Said that. Gaudas are residing and these reside.
No, caste, this caste. Irrespective of castes, people are residing parallel to the National Highway.
All are entitled to enjoy this.
Yes, my lord, sir. All are entitled to enjoy the fundamental rights. I'm going to establish.
Making good arguments in between, you're making a bad argument. Yes.
My lord, para number 21. Next page, my lord. Third line, under which the law would be valid if imposes reasonable restrictions on exercise of right in the interest of the general public.
Which judgment? 21. Same?
Same judgment, my lord. Next para, 21, next page. Third line, my lord.
Primary question which requires consideration.
No, same para, next page, my lord. Neighbor. Third line. Under which the law would be valid if imposes reasonable restrictions on the exercise of the right in the interest of general public. It is not disputed that the question of reasonableness is justifiable matter which has to be determined by the court. This honorable court may decide whether it is a reasonable restrictions or not. Will come argument after this para, my lord. If courts hold the restrictions imposed by the law to be reasonable, petitioner would certainly have no remedy. If, on the other hand, they are held to be unreasonable, Article 13, Clause 1 of the Constitution imposes duty upon court to pronounce the law to be invalid and extend that it is inconsistent with the fundamental rights guaranteed under Part 3 of the Constitution. It is very clear that, well, while relying on my case, giving the provision of any alternative road, by making a payment, by collecting the fee, then it is the reasonable restriction. If it is not going to be give any communication road, hence it can be clear violation of Article 19, Clause 1D. That is a reasonable. Either it may be a service road, or it may be a village connecting road, or it may be any small road. There is no road communication traveling from one place to another place. My lord, this is one. And also, next, kindly may peruse the case is State of Himachal Pradesh and another versus Umad Ram Sharma and another. Kindly may come to para number 11, my lord. May I read, my lord? It appears to us that the facts of the case, the controversy lies within short compass. It is well settled the person who have applied to the High Court by the letter of persons affecting by the absence of the usable road because they are poor Harijanas residing of the area. They are assessed by communication, internet life outside is obstructed and are prevented by the absence of road. The entire state of Himachal Pradesh is in ill and without workable roads, no communication is possible. Every person is entitled to life as enjoyed in Article 21. Here, that the Article 21 of Constitution. And in facts of this case, read in conjunction with Article 19, Clause 1, Clause D of the Constitution, and in the background of the Article 38(2) of the Constitution, every person has a right under Article 19, Clause 1, Clause D to move freely throughout the territory of India, and he also right under Article 21 to his life, and that right to under Article 21 embarrasses not only physical existence of life, but the quality of the life and for residing of hill areas. Access to the road is a access to the life itself, my lord. This proportionate as well as settled, we accept the propositions that there should be a road communication in reasonable condition. In view of our constitution imperatives, and denial of that right would be denial of life. As understand, it is the richness and fullness by the ambit of the constitution. To residents of the hill areas are so far feasible and possible, society has constitutional obligation to provide the road such for communication. This is my part number 1 of submission, my lord. This is purely on basis of the constitutional infringement of fundamental rights. Clearly that Article 19(1)(d) and 21, my lord. Number 2, now I come to the material facts with the following documents. My lord, while I experienced it in a traveling, I experienced that the inconvenience and deficiencies in the road. Hence, I made a complaint before the National Highway Authority to relief, my lord. Hence, they have given reply. Kindly may peruse page number 56, my lord. Also, hereby I am submitting the road manuals, my lord. Actually, national highway roads are constructed and developed as per the guidelines of the IRC roads manuals and specification, irrespective of 2-lining, 4-lining, or 6-lining of highway. Here is the covered lining manuals hereby submitting, my lords.
So in this service road provision is there?
Yes, my lord. Yes, yes. I will argue. I will come to the point. My lord, kindly, for a moment, kindly come to page number 12, my lord. For a moment. My lord, when I starting from the toll plaza, there are many villages situated parallel to the National Highway road. The villages names have appended in petition page number, in page number 12, my lord. Second column is the village name. Third column is the kilometers calculated from the toll plaza. How it is, how the kilometer, how it is to be as kilometer, my lord. This is one. Second page, madam. My lord, next page.
Saying that service road is not available.
No. There is no, my lord, none. I have two veracity of the 2 point. Number 1 is infringement of fundamental right by not providing the service road is number 1. Number 2 is by unauthorized road, they are collecting the fee from the public. Now I am arguing in part of the, it is the, I am stating that it is unauthorized toll with the help of the documents relied on by the IRC, Indian Road Congress, road specification manuals. And also admittedly, NHI authority admittedly, they are stating that we are failed to meet the functions as confirmed in the legislation act.
Kindly listen, in the standard specifications for 2-laning of state highways, is there any provision for keeping service road mandatorily?
No, my lord, no, my lord. But
There is.
the road width of the service road is mentioned here. All these specifications are not mandatory, my lord. As per the guidelines, they should develop the national highway roads.
Service road provision is there in the guidelines?
No, my lord, no, my lord. Service road is purely, I'm challenging upon the constitutional merits. Here I'm going to challenging only with the said national highway toll is an unauthorized only, not with the service road provision. Now I'm arguing the matter only for the unauthorized. The said national highway road is unauthorized. My lords, here is kindly may peruse the kilometers, my lord. One village to another village, there is only a 100 meters, 2 kilometers, 3 kilometers, like that. out of 56 kilometer, there is 21 villages we have to pass in the national highway. My lord, if the
Who drafted this petition?
I am the
And who worked so much hard? Both of you. Both of you worked hard too.
yes, my lord.
Who
Both
had-
we work together and prepare this petition, my lord.
Only merit in your petition is that you are developing good. So notice,
You know?
notice.
My lord, I will argue with the, my lord, the said NHI road is unauthorized. I will come up with the documents.
So
my
we are
lord.
issuing notice.
My lord, kindly, I will convince the court, kindly hear the matter, plainly, my lord. Just 2 points. Okay, 2 points, my lord. I will go with the direct point. Okay.
So we are issuing notice, mister. What more you can do? Oh,
My lord,
My lord, I
kindly hear
accept
the-
notice for respond number 2, my lord.
we are issuing notice to other side.
Madam, my lord, I need an interim order in this matter, my lord. My lord, the road is my lord, the road width is, wait, my lord, for a moment. The road width is, as per the guidelines mentioned here is, 27 feet. Here is, as per the guidelines, but the actual road width is here is only 23 feet, my lord. How it can be possible? Prima facie, on prima facie, it shows that it is the unauthorized road. On prima facie ground and constitutional validity, this honorable court may pass the interim order. And I will argue the matter with the material facts, my lord. Kindly may permit me to argue the matter, my lord. My lord, the road width is 23 kilometer.
We are giving 10 minutes.
Okay, okay.
10 minutes.
Okay, okay. My lord, the road width is 23 feet. If the truck width is, yes, if the truck feet is 7 feet, how can another vehicle can overtake the road? By inevitably, behind the truck vehicle, he has to overtake by another lining. There are the 2 lining of the road, my lord. 1 line opposite. If I go the opposite line, it is the violation of the line crossing 1 way, and other impediment will happen. This is what number 1. And also, my lord, kindly may come to page number 57, my lord. Uh, 2D, point number 2D. I made a complaint in the left-hand side. The reply given by the National Highway is the right-hand side. I should travel via many villages and traffic signals. There is no bridges for the free movement. They have given reply it as the stretch of the Kerala border to Kollegala main road developed by the state PWD, my lord, but later it handed over to the National Highway. And also, when the state PWD developed the road, as per the, kindly see, my lord, for the 2 laning of state highway mentioned, they have developed the road as per the state highway guidelines, not the standard highway, not the national highway standards. Hence, itself is invalid. And they are collecting the fee from the public as per the national highway fee rules. How can it be possible, my lord?
You are Kaushik.
Yes, my lord.
Since
The road has developed by the state PWD as per the guideline of the state highway, but they are collecting the fee as per the standard of national highway fee rules. How can it be possible, my lord?
how long you are practicing?
1.5 years, my lord.
1.5 years. So where to stop is also a good part of argument. We are issuing notice only because
Okay.
you are developing your matter.
Okay. Kindly may have emergency notice also may be preferred.
No reason.
My lord, I accept
Obliged
notice
by
for
number
respond number 2, my lord. I accept notice for respond number 2, my lord. R2,
Why do,
Union of India.
why do you appear?
Number 9.
My lord,
Why do you appear?
my lord, Union of India is party as
Welcome,
respond number 2, my
But
lord.
where is only issuing notice, nothing more. Only because he tried well to develop his matter. That's all.
Please,
No other-
please, please.
Serial number 9. Mr. Jeevan Saab, 14%.
My lord,
My lord, I am not advocate, but I am facing one case, sir. In favor of a student, my lord, ITI, JODC and diploma student who are not allowed for the law degree. Even though allowed, every degree, my lord. In every degree course, ITI, diploma and JOD student are allowed for the admission, expect law degree, my lord.
Expect
Law degree.
everywhere law. Law is everywhere. Yes.
My lord, I don't know well English, my lord. In case of
You don't know English.
no, well English, I don't know.
Not
I am not an advocate also.
not advocate. Don't know English very good.
English well, sir.
Well,
If you permit, I am arguing in Hindi also. Hindi.
Hindi will not permit. Official language of the court is English. If you are not well versed in the language of English and not able to put forth your case properly, then we direct the committee to reconsider your certificate to appear as party in person.
Because of
We are not here to waste our time.
No, my lord, I am not wasting any time. Just, madam, so several circulars government are provided.
What is the subject matter? What is the grievance?
Only
What are the arguments?
regarding this, my lord,
What?
the 10+2 is considered for the ITA diploma and
It is entirely a policy matter.
they are considered, my lord, already considered.
13% at length,
But
learned additional government advocate, Mr. Nilofer, appeared upon service of copy of bill in advance and assisted the court, the prayers, the subject matter and the prayers in this public interest petition. In this petition, styled as public interest petition, entirely falls in the realm of policy. Full stop. No relief is booked in this petition. Dismissed.
Serial number 10. Mr. K.S. Raghuram.
Serial number. This is that temple matter.
yes, sir.
Second.
Serial number 11. The Deepak Diyar.
My lords, I appeal for the petitioner, my lords. Lords, this is regarding the provision of section 95 of the Land Revenue Act.
Here you are enjoying some partial interim relief also.
Yes, my lords, I have an interim relief, but what has happened is, my lords, plantation crops, Bane lands,
So then why
all
you
of those things are being
are-
given NOCs, my
why
lords.
you are challenging this annexure?
My lords, the technical committee is issuing NOCs, even to lands which are not agricultural in nature. This is the point. my
And then
lords.
you challenge those orders. In individual cases, you may have good cause, but then why the prayer for setting aside this annexure that we are not able to understand.
My lords,
It's only a committee constituted to issue the conversion certificate.
my lords, NOC has to be given.
You are saying that certificates are issued wrong in a wrongful manner.
Yes, my lords.
So then,
My lords, what has happened is, my lords, I will bring this honorable court to the legal audit report of the Auditor General, my lords.
so then you challenge the individual cases.
My lords, what has happened is, my lords, this technical committee is not taking the Auditor General's report into consideration. That is the point. Auditor General report may kindly be taken into. I draw the attention of this honorable court to the Auditor General report, my lords. Second. Yes.
So can I have a copy?
Karnataka Land Revenue. No, there is no power to convert.
No, my lords. And the Auditor General report says Bane lands, Jamma lands, and the plantation crops does not fall under section 95 of the Land Revenue Act.
That we'll see, but let us see section 95 first.
Yes, my lords. My lords, section 95, use of agricultural lands and the procedure for use of agricultural lands for other purposes. 1. Subject to any law for the timing in force regarding erection of buildings or construction of wells or tanks, an occupant of land assessed or held for the purpose of agriculture is entitled by himself, his servants, tenants, agents, or other legal representatives to erect farm buildings, construct wells or tanks, or make any other improvements thereon for the better cultivation of the land or its more convenient use for the purpose aforesaid. Clause number 2, my lords. If any occupant of the land assessed or held for the purpose of agriculture wishes to divert such land or any part thereof to any other purpose, he shall, notwithstanding anything contained in any other law for the timing in force, apply for permission of the Deputy Commissioner, who may, subject to the provisions of this section and the rules made under Act, refuse permission or grant it on such condition as he may think fit.
So this is committee's function falls under Rule 2.
Yes, my lords. Rule 2 is Deputy Commissioner on agricultural lands.
These are not agriculture.
They are not agriculture. That is what the Auditor General report says, my lords. That is what I want to bring into the knowledge of this honorable.
Which are these lands?
My lords, they are the Jamma lands, Bane lands, and the plantation crops. Plantation lands. Plantation lands are not agricultural lands.
Auditor's report is not a law.
My lords, the Auditor General report says that. My lords, may kindly.
Auditor's report cannot be treated as law.
Lords, may I be permitted to read the Auditor General reports? My lords, it clearly says.
Auditor's report is not a law.
I know, my lord, it is not a law, but it is clearly said land grant rules has to be taken into consideration. Land grant rules, definition of agriculture, I bring it to the knowledge of this honorable court, the definition of agriculture.
That you show.
Yes, my lord.
Definition. Agriculture
Sorry.
defined.
Yes, my lord. My lords, I take this honorable court to section 2 of land grant rules, 1969.
Karnataka Land Grants of 1969.
Yes, my lord. Agriculture means horticulture, clause A. Clause B, the raising of crops, grass, or garden produce. Clause C, dairy farming, poultry farming, the use by an agriculture of land held by him or a part thereof for grazing of cattle, but does not include allied pursuits like breeding of livestock, grazing other than pasturage of one's own agriculture cattle,
and such other pursuits as may be prescribed, or the cutting of woods only. And D is arboriculture. My lords, this is the definition of agriculture under the land grant rules. I draw the attention of this honorable court to subclause 9 of the land grant rules. Plantation crops means cardamom, coffee, pepper, rubber, and tea. My lords, plantation has got a specific definition, but it cannot be treated as an agricultural land. That is what the Auditor General report clearly establishes and says.
That will see, but agricultural means raising of crops.
Yes, my lords, raising of crops. Yes.
Plantation is also crop.
No, my lords, it is not raising of. That is what the Auditor General report says. My lords, may kindly be permitted to take this Auditor General report, and I will try to.
So coffee, planting coffee, cardamom, pepper.
Yes, my lord, they are not agricultural lands.
No,
It does not fall under the.
It is not an agricultural activity.
No, my lords, it is not an. That is what the Auditor General report says. May be permitted to read the. My lords, I.
You have to show that auditor's finding or opinion or report has enforceability or efficacy in law.
My lords, I will.
You show this, where is that?
Yes, my lords. First, I will bring the. My lords, I draw the attention of this honorable court to page number 3, my lords.
Page 3.
Yes, my lords. My lords, after enactment of the Karnataka Land Revenue Act, as narrated in Revenue Settlements of Coorg 1910, there were various kinds of lands in possession for the Rethoseg, Jamma land, Sagu land, Umli land, Jahagir land, which were granted earlier by the erstwhile kings of Madikeri, and thereafter by the British East India Company in appreciation of the service rendered by the people in the army. Jamma and Sagu lands are wetlands fit for cultivating paddy. The difference between Jamma and Sagu lands, which regards to land revenue, was Jamma lands were assessed for 50% of the land revenue, whereas Sagu lands were assessed for full revenue. A considerable area of the forest land adjacent to Jamma and Sagu lands was considered necessary for grazing, leaf manure, firewood, or timber for agriculture purpose, the extent of which varying from few acres to 300 or more acres. These allotments were recorded in the revenue records as Bane lands, with free of land revenue. If such land is attached to a Jamma or a Sagu land, these were called as Jamma Bane and Sagu Bane lands. The holders of Bane lands enjoy certain privileges to extract green leaf and timber, etc. for the better cultivation of their warj, that is wetlands. This land was not to be cultivated. The Bane holders have no proprietary rights over the Bane lands, and the right of the Bane lands always vests with the government, which was upheld in the various courts judgments in TV Ramaraju Naidu versus Divisional Forest Officer Madikeri, 1975, 1 Karnataka Law Journal 302. My lords, now I draw the attention of this honorable court to next page number 4. From the middle paragraph. From the above narration, it was evident that there are 4 types of Bane, Jamma lands, Sagu lands existed as of now. Bane lands which were alienated in violation of grants condition prior to enactment of regulation. Such lands were brought under the ambit of land revenue without collecting any land cost. Bane lands which were alienated between regulations 1899 and enactment of Act 1964 under section 167 of regulations 1989 with the prior permission of the Assistant Commissioner on collection of Nazarana. Bane lands which were used for cultivation in violation of grant conditions, that is, Bane land shall not be put for cultivation but not alienated. Such lands were brought under the ambit of land revenue. Bane lands which were neither put to cultivation nor alienated, hence no land revenue fixed. My lords, next I will take this honorable court to next page, that is clause B, it starts, my lords. Further, as section 95 subclause 2 of the Karnataka Land Revenue Act, if any occupant of a land held for the purpose of agriculture wishes to divert such land to any other purpose, he shall apply for permission to the DC. This implied that only lands held for agriculture are eligible for change of land use. As per definition of agriculture, as provided in Rule 2, subclause 2 of the Karnataka Land Grant Rules, coffee plantation and wetlands, which were categorized separately as plantation crops and wetland crop, are not included in the definition of agriculture. Hence, not eligible for conversion. My lords, however, on a scrutiny of conversion files, it was observed that the DC has accorded permission for conversion of coffee plantation lands, wetlands, Jamma and Sagu lands, and Bane lands, that is Jamma Bane and Sagu Bane lands, which were the property of the government in violation of provisions of Karnataka Land Revenue Act 1964, as stated in A.B. above, and which was not in order. Few illustrative cases are given in the enclosed annexures. My lords, further, the Appendix 3 of the Coorg regulation, Bane is defined as forest land, granted for the service of holding of wetlands to which it is allotted, to be held free of revenue by the cultivator for grazing and to supply leaf manure, firewood, and timber required for the agriculture and domestic purposes for cultivator, so long as he continues in possession of the wetlands, as narrated in the case law, that is C.K. Puvaya versus State of Karnataka, page number 33. Besides, that Chapter 5, Para 91 of the Revenue Settlements of Coorg 1910 also defines the Bane land as forest lands. In view of the above land is forest land, hence belongs to the Forest Department. The Revenue Department should not have any jurisdiction, any authority over such lands. Hence, actions of Revenue Department fixing of land revenue on Bane lands according to permission for sale and change lands use of Bane lands was not in order and beyond its jurisdiction. On this being brought to the notice, it was agreed to examine and to furnish compliance in due course. My lords, this particular issue was time and again enunciated by the people of Kodagu, requesting not to convert because of heavy landslides in Madikeri and Kodagu districts, my lords. And this Kaveri catchment area, the whole Kaveri River, the birthplace of Kaveri River is there is no catchment policy of this river. And if conversions and NOCs are given for such kind of plantation crops, which does not fall under Section 95 for its consideration, my lords. This is the question of this particular repetition, my lords. And this Auditor's General report, time and again has been brought to the notice of the DC, but technical committee also, and previous to that also, has not taken into consideration.
But basically, it appears that this view is in order to
My lords, it is as
take
per
out this plantation crop and wetland crop from charging land revenue.
my lords.
My lord,
Land
may I
grant
make
rules
one
clearly-
submission before my learned friend can proceed, my lord?
My lord,
My lord,
I
he's
will complete
only-
it, my lords. I'll complete it. Land grant rules definition may kindly be looked into, my lords. Plantation crops does not come under the definition of agriculture. So how can Section 95 of the Karnataka Land Revenue Act may be imposed? That is my question. And for which objections, I think probably is not at filed to by the
What
state.
is this arboriculture?
Arboriculture, yes, my lords, I have verified. Arboriculture is, I think it is pertaining to bamboo cultivation. my lords. My lords, it is the cultivation of trees and shrubs.
Is Jamma and Sagu are the species of Bane land.
Yes, my lords. Jamma, Bane are all wetlands.
All are Bane land.
Only for
What is Bane land?
Bane lands is also the definition, my lords. It clearly says,
It is there. Land.
it is not there here, my lords, but it is in the Karnataka Gazette. Bane lands, Jamma lands, and
Point for we want some further material.
much obliged, my lords. I will do that, my lords. 1 week time may be given.
What is the plantation crop? You also find out
Well, my lords, it is
some
there.
scientific definition.
Yes, my
Otherwise, we
lords.
know what is plantation crop.
I will do that, my lords. I will definitely come with the.
And he appears
But-
to a point because.
My lord, he has a point, but he cannot take me by surprise, my lord. My lord may see the prayer. It's only for quashing of this conversion from agricultural to non-agricultural purposes.
Setting aside of that,
Technical committee.
committee.
No, for the impugned order, my lord, that order is, my lord may see, conversion, my lord, the committee that has been formed. Constitution of the committee, my lord, to consider applications of
So who has,
conversion.
who has formulated this committee?
My lord, the government.
So how can government formulate? The power is given to deputy commissioner.
That is what the question, my lords.
That is the another question.
My lord, please see the grounds, my lord. My lord, please see the ground.
The committee can't be delegated because it is the deputy commissioner who is vested with the power.
My lord, even that if I went.
Whether it can be delegated to a committee is also a question.
My lord, all that should be raised, my lord. I should have an opportunity to meet that.
Highly.
My lord, my lord is, my learned friend is now contending, arguing before my lord, and he expects me to
No,
meet those contentions.
He's already enjoying that some relief. Where the court has said that the all conversions henceforth will not be treated to.
Treated. Yes, my lord, that order is there.
It's a very significant order. It is a great significance. When court says that the conversion granted by the committee shall not be a conversion as recognized. It has lot of significance in terms of the merit of the case. So what kind of conversion you are giving in wake of this interim order? It has no sanction under section 95.
My lord, if we were to, my lord, bring before my lord, such orders, at least that I can examine and make a submission to my lord.
You have filed, we are.
My lord, catching me by surprise like this, making these submissions, my lord.
When the points are good, you are taken by surprise.
No. No, I'm sorry if I've given that impression, my lord. It's not that. My lord, once if it is in writing, my lord, I can have an interaction with the official.
Much obliged.
We'll put up this on 25th of November.
Much obliged.
My lord,
Before
if
that,
it
I
is
will-
in writing, my lord, I can have an interaction with the officials and meet the contentions.
You meet the content.
My lord, but they are not writing. My lord may see the grounds, only 3 grounds raised, and out of that only 2. These are not the grounds raised. That's why I said he's taking me by surprise. And this is pending since 2020.
2020.
Yes, my lord, if we were to, my lord, a comprehensive petition, if it is filed, my lord, I can meet those contentions.
This is comprehensive.
My lord,
Purview.
my lord, please see the grounds, my lord, B and C.
What BL? What BL?
The grounds, page 30.
Prayer.
No, just before, grounds raised in the petition, page 30.
Wait.
My lord, this will have wide ramifications, my lord. Yes, so,
Very
my
right.
lord, I may be permitted to meet those contentions and then I leave it to my lords after I.
Nobody says that you can meet, but when you are going to file and
My lord, if he gives it to me in writing, I'll meet it.
this is the petition.
My lord, that is the grounds. That's what I said, my lord. The grounds may be seen B and C. And what he argued before my lord is totally new.
No, it is not new, my lords. Several representations were made to the DC.
Page 30.
This is PIL.
My lords.
This is PIL.
Yes, my lords.
If he were to file a comprehensive one, my lord, I'll meet those. And he can produce the orders also where the DC has converted some of the plantation estates. That also I can meet, but there are no such orders.
My lords.
Where is that order where plantation is converted into non-agriculture?
My lords, on this particular NOCs, plantation owners have applied for NOC certificates.
I don't
I will,
know that
that I will
information.
take it from the right, and I will produce it, my lords.
Let him file a
But
comprehensive
Annexure
one. I'm
C may
not
kindly
shying
be looked
away,
into,
my
my
lord.
Annexure C of my petition may kindly be looked into, my lords. It is a letter written by the Deputy Commissioner to the Principal Secretary. Any date may be fixed, my lord. Before that, I will apply for those necessary.
This can't be tinkered with, my lord. This writ petition, a fresh writ petition, comprehensive writ petition has to be filed.
She is right.
My lords, what has happened is, my lords,
The reason.
at the time when this matter was filed, it was COVID, 2018. Kodagu saw a very huge landslide, and not only houses were collapsed, but because of those things, even human lives were, the whole entire district of Kodagu is a heritage site, which is being declared under the Biodiversity Act. My lords, that is why this technical committee was formed. But this technical committee is issuing with, even after saying that plantation crops should not be given NOCs. They are giving, and Bane and wetlands. There are so many commercial buildings which has come in Bane lands.
We do not know that this committee is giving conversion permission only to plantation crops. Is it so?
My lords, yes, I will file those documents.
So
my lords.
therefore, your prayer is, your point, prayer and subject matter.
I will do
are
that,
good
my lords. I will
We
come,
debated. But
come
your
with
prayer
necessary-
is not complete.
I will come with necessary additional documents to be filed, my lords. Time may be granted.
My lord, a comprehensive one may be filed, my lord. Tinkering will not help.
No, my lords, I will see that it will be a comprehensive one.
You have not filed reply,
No, my lord.
although the petition belongs to the year 2020, comma. The record has not witnessed any reply filed by the respondent state government. Full stop. While the petitioner, public interest petitioner has challenged paragraph, while the public interest petitioner has challenged the order dated 4/6/2020 passed by the respondents, whereby the technical committee is formed for the purpose of conversion of land, conversion of agricultural land to non-agricultural purpose under section 95 of the Karnataka Land Revenue Act 1964. In that context, it was submitted by learned advocate Mr. Deepak R.
Yes, my lord. B.R. Deepak.
Deepak B.R. for the petitioner, that the committee is replete with the applications whereby the applicants seek conversion of
Bane lands, Jamma lands, and
Bane lands,
Bane lands, Jamma lands, and plantation lands,
Jamma lands and the plantation
plantation lands.
to non-agricultural purpose,
Yes, ma'am.
non-agricultural use. It was contended on the basis of definition of agriculture found in section 2 into bracket 2. Read with the definition of plantation crops, both in what? Plantation crops. In subsection 9 of section 2. Sorry, sub-rule, both rules. Sub-rule 2 of rule 2 and sub-rule 9 of rule 2 of Karnataka Land Grant Rules 1969. That the word agriculture would not include the Bane land, Jama land, or which land?
Plantation lands.
Plantation land. It was submitted that a clear clue is available from the rules in this regard, inasmuch as plantation crops are separately defined to mean cardamom, coffee, pepper, rubber, and tea. It was therefore submitted that the Bane land, which are the Bane land,
And Jamma lands.
Jama land, etc., where the plantation crops are grown,
And are wetlands, they are wetlands.
they are wetland, cannot be included, nor the rule-making authority has included them within the of the definition of agriculture.
Yes, ma'am.
It was submitted that if lands of such category, if not submitted, are permitted to be converted into non-agriculture, it would have a serious and devastating effect on the plantation lands in particular, and on ecological balance of the region in general. Full stop. While the court highlights the controversy involved in the petition as above, this court has already passed an order on 27/1/2021, whereby two significant observations are made. Firstly, it is stated by the court that the order impugned in the petition dated 4/6/2022, by which the state government has constituted a technical committee to authorize the conversion of the lands, is not backed by any specified statutory power, which could have been exercised in formation of the committee. Secondly, a part interim relief is granted by observing that the grant of no objection certificate by the technical committee under order dated 4th June 2020 shall not be construed to mean that a permission for conversion in accordance with section 95 of the Karnataka Land Revenue Act 1964 has been granted. It necessarily implies that all conversions which may be permitted by the aforementioned committee shall not have the sanction of section 95 of the Act. Full stop. The present public interest petition paragraph raises important issues required to be finally thrashed out. a prima facie case is made out. Therefore, rule returnable on 25th November. Full stop. Even as the petition is 4 years old, no reply is filed. Therefore, it is directed that the respondent competent authority shall file exhaustive reply dealing with all the aspects arising from the controversy. The petitioner is also permitted to add to the pleadings and his contentions as may be advised. Full stop. During the pendency of the present petition, ad interim order as granted above shall continue. Full stop. The court is inclined to take up the hearing of the petition peremptorily once the reply is filed. Put up at 2:30 on 25th of.
My lord, may I make one submission? My lord, if my learned friend to give my lord the additional pleadings, my lord, I will be able
in
to
advance, I will give it.
correspond. My lord, 25th is the too short a date, my lord.
20th petition of 2020.
My lord, yes, my lord, but my lord, I didn't know this was pending. Otherwise, I wouldn't have moved. But I need, my lord, a lot of discussion on this. My lord, it's going to have wide ramifications, my lord. 25th is very short, my lord.
We want it to have wide ramifications.
No, my lord, I'm sorry, my lord. My lord, this is this is purely academic. My lord, no cause of action. My lord may see along with that, my lord, no orders have been produced to show that, my lord, the committee has passed orders, my lord, giving permission for conversion. My lord, third party interest is also created.
We are not concluding anything.
My lord, 25th is too short, my lord.
We'll grant time, but today we.
My lord, the pleadings.
You file edit.
I will do
before
that, my lord.
25th, anything you additional.
I will do that,
In
my lord.
terms of material, pleading.
Yes, my lord.
Prayer, whatever you feel. We are not
That
advising.
may be on the
We are not
25th.
advising you.
No, my lord, I will.
We are not issuing rule, then let it be.
My lord, may I make one submission? My lord, on 25th, he may give me.
Send out
that,
to
my-
25th at 2:30, you file bill.
Much obliged.
Obliged.
All
And
order, entire
I'm
order will
grateful,
remain
my lord.
except rule. Yes.
ఏంటి మనది?
Yes.
Sir, green bench matters, still number 12, to Mohammed Taib.
What is it?
Lordship, this, I am not seeking any interim relief in this matter, Lordship. I am seeking as a writ of mandamus, seeking a direction against the respondent number 1 to consider my representation for complaint against the illegal mining, which is happening on the scheduled property of a Hoskoted Taluk, Lordship, which this property is actually, it belongs to me, but I have handed over the position to respondent number 2 under registered agreement of sale, registered agreement of sale, Lordship. And this illegal mining is going on from the July 2022. I had given a representation 16/8/2022 to the respondent number 1 to take action against the illegal mining, which is done by the respondent number 2 on the shoot scheduled property, which stands in my name, Lordship. I filed a suit OS case also against this rules for specific performance against the respondent number 2, Lordship.
So ultimately, the dispute appears to whether the area where the number 2 is carrying on the operations.
Yes.
Are part of the sale deed or not?
No, it's not. Lordship, kindly appreciate. This
You have sold the land.
No, I have sold the lands under agreement of sale.
Part of the land.
Yeah,
under it.
entire land and handed over the possession.
Now you are saying that the other area, then this all it is being
No,
utilized.
no, the same area, illegal binding is going on. Same area. So for that reason, and without any license, the mining is going on that area. We had reported to the respondent number 1. So far, he has not taken any action. In a future,
What is your prayer?
my prayer is to consider the representation, Lordship. Presentation is document number 1. Annexure A. Presentation given to the respondent number 1. So far, no action has been
You
taken.
have purchased the land.
No, I am the original owner, Lordship.
Original. You
I
sold.
have handed over this property with the possession under a registered agreement of sale to the respondent number 2. And he has not executed the sale deed. For the, against that, I have filed a OS suit also for the suit for specific performance. That OS number 1599/2022. It is pending for consideration.
My lord, through the mines department, he is trying to shoot at, my lord, for obvious personal gains, my lord, to his purchaser. That cannot be done. My lord may see the prayer he sought for, to direct the respondent number 1 to conduct a survey and stop the illegal mining in the said suit scheduled property. That cannot be done.
Why?
My lord, direct this thing.
Lordship, I have filed
Direction
another suit
through my lords, a positive direction.
for the relief.
It will not. be as
We'll consider the representation in accordance with
Yes,
law.
Lord.
Yes.
That is only my submission.
Heard learned advocate Ms. so-and-so petitioner and learned additional government advocate Ms. Srimati Neelo for the respondent state and its authorities to appear to assist the court in upon service of copy of the petition in advance. In this petition filed under Article 226 of the Constitution, the petitioner is prayed to direct respondent number 1, Deputy Director, Bangalore, Deputy Director, Department of Mines and Geology, Bangalore, to conduct survey and stop the alleged illegal mining in the property, parcel of agricultural land bearing survey number 51/P8, head measuring 1 acre and 34 guntas, situated at Meduru village, Nandagudi, Hobli, Hoskot Taluka, Bangalore, rural, as described in the schedule. The bounds of which is described are described in the schedule. The prayer as above paragraph is advanced in the context of facts pleaded in the petition inter-alia that the petitioners are the owners of the property bearing owners of the said property, which was purchased by the petitioners under sale deed dated April 8, 2006, registered sale deed dated 1886. It is stated that since respondent number 2 was willing to purchase the said property, now the petitioners have executed the sale deed, sale agreement, an agreement to sell in favor of respondent 2. It is
With
further
possession.
stated that upon execution of the agreement to sell, possession is also handed over to the vendee, proposed vendee, on 24/1/2019, which agreement to sell has also been registered with the Office of Sub-Registrar, Hoskotek. The allegation paragraph is that respondent number 1 has started, respondent 2 has started mining activities in the land illegally and that for such illegal activities, the petitioner may have to face the consequences without fault of his own. It appears from the statement made by the petitioner in paragraph 4 of the petition that a suit for specific performance is also filed against disclaimer 2. While prima facie while the dispute essentially appears to be between the petitioner and disclaimer 2, only for the reason that the petitioner has made allegation about illegal mining activity being carried on the land in question, the court is inclined to grant limited observation, while disposing of the petition as meritless, by requiring the competent authority respondents to look into the allegation as to whether any illegal mining activity is going on at the hands of HNDS, disclaimer 2, or by anybody in the land in question. If upon a fact-finding inquiry, such activity is found to be carried on, action in accordance with law may be taken, full stop, except the above limited observation, and without expressing any opinion merits, this petition is dismissed.
Apply. Serial number 30, Anand Muttali.
My lord, an application filed by me under section 8A, clause 3 of the Mines and Minerals Development Regulation Act, my lord, seeking extension of the lease period has been rejected by the second respondent.
Notice written.
Please, my lord.
Notice written on 3rd December.
Number 14, Shiv Kumar KV.
My lord, I appear for the petitioner in this case, please, my lord. The petitioner has challenged the order passed by the second respondent, my lord, wherein the second respondent has passed an order, my lord, directing the authorities to consider both the applications filed by the petitioner as well as respondent number 4. My lord, the contention of the petitioner is, my lord, there are two different kind of minerals, my lord. The respondent number 4 filed an application for a grant of acquiring lease in respect of ordinary building stone, whereas the petitioner, my lord, has filed an application for a grant of acquiring lease in respect of specified minor mineral. Lord, by the application of the 4th respondent, my lord, came to be rejected as far back as in the year 2021. My lord, against which, my lord, the 4th respondent has not filed any revision or writ petition seeking restoration of his application. By virtue of the amendment carried out to Karnataka Minor Mineral Concession Rules on 17/3/2023, my lord, a representation was made to the Director, Department of Mines and Geology here in second respondent. My lord, without any authority of law, without any jurisdiction, my lord, he has passed the impugned order. That too, my lord, based on the legal opinion furnished by the legal cell, which have produced at annexure annexure Y, my lord. The fourth respondent's application came to be rejected, my lord, on 27/10/2021 wide annexure T. Against this, my lord, he has not filed any revision or writ seeking restoration of his application. The impugned order is passed on an application which was not in existence, my lord. This is completely covered by a law, by the order of this honorable court.
Lord, wherein I have produced a copy of that order, my Lord, at annexure. X, please, my Lord, at page 168. Annexure T is the rejection order of the application of the fourth respondent, my Lord. It is on 27/10/2021. That application is not restored.
So what are you challenging now?
My Lord, I'm challenging the order passed by the Director, Department of Mines and Geology, which is produced at annexure A, my Lord, on two grounds. First ground is, my Lord, the Director of Mines and Geology has no jurisdiction to to restore the application of the fourth respondent, which is already rejected as far back as in the year 2021.
That is not the subject matter. The subject matter is the order whereby your application for 3 acres of land is
Agreed.
found to be not acceptable because 1 acre is overlapped.
Yes.
That's all.
No, my Lord, my contention is,
That is
1
not
minute,
the-
1 minute,
that
1
is-
minute. I will convince, my Lord. The application filed by the fourth respondent is in respect of ordinary building store. My Lord, whereas my application is filed overlapping on the application filed by the fourth respondent in respect of specified minor mineral black granite. My Lord, the fourth respondent, if he is accorded sanction for a grant of acquiring lease over 2 acre, he cannot acquire both the minerals. He cannot query both the specified and non-specified minor mineral,
You are
for which the
making-
parameters.
You are making your application to respond to and saying that he has no jurisdiction to decide your own application.
No, my Lord, no, it's not so, my Lord. Finally, my Lord, the Director of Mines and Geology says that let the area be apportioned between 2 persons, leaving an area of 1 acre.
What do you say?
My Lord, I'll seek instructions and make my.
We are not issuing notice, taking step.
In the meantime, my Lord, I have sought for an interim order not to,
We are not issuing notice, where the question of interim order.
please, my Lord.
Learned additional government advocate. Srimati Nilofer Akbar will take instructions to apprise the court about the controversy and the stand of the respondents with regard to the grievance of the petitioner on the next date, stand over to 29th of November.
Please.
Mr. Rakshit Ravindra.
Difficult predicament. Your lordships were not directed that applications should be filed to the Dam Safety Committee. I'm a case, my lord, where I'm carrying on quarrying without blasting. Your lordships may recall, my lord, 2-3 times the matter had come up. Your lordships, my lord, were kind enough, my lord, to kindly turn to page 170, my lord. There's a direction issued by your lordships.
Page?
That Dam Safety Committee should go into this issue whenever a person raises. I go before them, ask them that I'm not using any blasting and this only cutting that I'm doing. They say, my lord, that we have no jurisdiction to decide anything in spite of your lordship's order. Please see their endorsement which they issue me.
Page?
The annexure A at page 24. At 25. We bring to their notice the order passed by your lordships. Last para at page 25. However, since the task of reviewing the permission of mining does not come under the purview of Water Resources Department, as mentioned in letter reference 1, there's no blasting in their activity. They've been requested to submit a report to the relevant competent authority and convince them to obtain a permission. This is what the Dam Safety Committee says. Then Lord Director of Mines, he issues an endorsement at annexure B after noticing all the orders, my lord, that were made. At page 37, he takes note of the order passed by your lordship, my lord, at para 5. Lord, para 5, at my lord, the previous page, at page 36, this is the extract of your lordship's order, my lord. Last para at page 34, this is extract.
The terms of reference to be decided by for the.
No, your lordships were not directed because
Are we directed, but what is the?
My lord, the case
They
is
have to, my
posted on
lord.
the 14th of November, my lord. My lord, there what has happened is, my lord, we have referred the matter to the Indian Institute of Sciences to study and to
Direction
submit a
was
report.
given, madam, in the presence of the government advocate.
Yes.
And you accepted that the Dam Safety Committee has power to go into this.
No, my lord, my submission was this, my lord. My submission in the earlier round, my lord, was I'm not using any blasting, so I should be permitted. Your lordships, my lord, after hearing that said, this issue of individual issue should, the Dam Safety Committee should take a decision. That is what your lordship's order is, my lord.
What the committee has taken stand?
The committee, my lord, says that I have no jurisdiction to decide this. Kindly see your lordship's order, my lord. So
Where is our order?
detailed order.
Where is our order?
At page, my lord, there are 2 portions. Kindly turn to, my lord, page 170. The middle of that page, my lord, order on IA 6 of 24. My lord, your lordships may recall what had happened was there was an interim order in some other case, and I sought permission to implead in this case, and this was the order, my lord, your lordships made. The interim application filed by so-and-so seeks to be impleaded as party respondent in the present proceedings. The case of the proposed party is that she was granted quarrying lease for black granite over 32.32 acres of land in survey number so-and-so with effect from 23/5/06. It is a case of the applicant that she has not employed the use of explosives in quarrying operations and adopts non-blasting method for cutting the block. It is contended in the application that in view of the order dated 8/1/24 and the subsequent orders passed by this court in the present proceeding, she is not permitted to continue quarrying operations, that the orders operative are prejudicial to her. She is interested party in the outcome of the proceeding, therefore impleadment is paid. As already noted above, the Dam Safety Committee is functional, and this court has required the Dam Committee to go into the individual cases and address the grievances of individuals. It will be open for the proposed applicant in this application to approach the State Committee for Dam Safety with appropriate application. If such application is made, the committee shall go into it and decide strictly in accordance with law. The decision shall be placed before the court in the present proceedings before it would be implemented. We submit that application at a next page, my lord, at page 171. Paragraph number 5. Because I said, my lord, that 8124 order is a blanket order. It can't be made applicable to people who don't use blasting. In that context, this is what your lordships, my lord, directed at page 171, paragraph 5, my lord. We sought a clarification. The Honorable Court then, my lord, made this order. The court, paragraph 5, my lord, the court is of the view that the order dated 8124 is not required to be clarified. It is clear in itself. Not only that, in view of the order passed herein above in the main proceeding, as well as in IA 6 of 24, it is always open to the applicant to approach the State Committee for Dam Safety with a prayer, which sought to be made before this court in the present application. So my prayer was, permit me to carry on mining because there's no blasting, there's no vibration. My lord, I have also, my lord, placed an expert report just for information, my lord. He goes into this, examines what activity we are doing, comes to the conclusion that there is no vibration that is being caused at all. Now, my lord, kindly appreciate my predicament. From January of this year till today, my mine is closed. Because of the, my lord, blanket order of this Honorable Court, I've been moving your lordships, my lord, time and again. All that I'm saying, my lord, is your lordship said, let the Dam Safety Committee, my lord, they can give a report, whatever report they want to give at later stage. Today, the only limited question is, my lord, I have a mining plan. The mining plan says what I show.
My lord, can I make one request, my lord? My lord may have this on 14th because the connected matter is also on the 14th.
That will keep, but this committee says that task of reviewing the permission for mining does not come. This is not the reviewing of permission. This is about whether his activity involves any blasting.
Yes.
Which may become a possible danger to the dam safety. That committee can, you place on record the terms of reference of the committee or area of jurisdiction of the committee. Even if there is nothing like this in the area of jurisdiction, it is our order.
Yes, Honorable Court has directed. My lord, the reason why your lordships directed them was.
And you have to find out how to implement the order.
Yeah.
If not by the committee, by any other authority.
My lord, could I make a request to have this on Tuesday? Advocate General is not in station.
No difficulty. Heard learned senior advocate Mr. Nagananda, assisted by learned advocate so and so. The petitioner calls in question the response cum decision of the Dam Safety Committee, whereby the committee has flatly refused to carry out the directions of the court in the earlier order, passed in the earlier petition. By observing that the task of reviewing the permission for mining does not come within the purview of the functional sphere of the committee. In the earlier proceedings of writ petition number paragraph 19835/2023, the petitioner herein was proposed impleading party who came before the court with a case that mining operations by the petitioner ought to have been permitted at the place sought to be carried out, inasmuch as it does not involve any blasting, does not involve any blasting, full stop. It is the say of the petitioner it was the say of the petitioner in the said context that since the petitioner's operation has it does not include any blasting, it will not endanger the safety of the dam. In light of the above specific case of the petitioner, the court passed order dated
31/7/24.
31/7/24. observing in paragraph 4 as above, and paragraph 4, page 170. This is paragraph. It was further stated. In the order passed on in IA. Then page 171, paragraph 5. Full stop. Despite the above clear directions, comma, the committee has come out with the above stand. There shall be notice to the respondents. Returnable on 14th, you want? 14th of November.
14th.
14th of November. Full stop.
My lord, till then, my lord, I filed an application, my lord. No harm is going to be caused to anybody, my
Oh,
lord.
no, my lord.
My
KRS
lord,
dam.
neither they are deciding the issue, my lord, nor are they saying anything about my application in spite of your lordship's order is now, my lord, 3 months old. I've given 2 representations. And I've given a technical report which says there's no vibration.
That day the respondents shall file reply.
Could your lordship direct, my lord, let them decide by then, my lord. Their only doubt is they can't decide. Now their order is there, my lord. Let them take a decision and place it before the court, my lord. On
Now,
my
the learned
application.
advocate general, my lord, is not in Bangalore for me to have an interaction and take a decision, my lord.
Then is not.
Forcing me
Not all that
to,
I'm saying, my lord, this can't be any prejudice to them, my lord. Your lordships have issued a direction on 31/7. I made an application. They say I don't have power. Now your lordships may please direct them that let them take whatever
that
decision
dam provides
and
drinking
place it
water
before the
to
court
us,
on
my
my
lord.
application, my lord. My application is important. I'm not concerned about others.
Just like how their livelihood is important, other person's livelihood is also important. The life is important.
My only humble request is this, my lord, if they want it on foot,
It clearly falls.
one way or the other, my lord, let them take a call and place it before the honorable court. Your lordships have already said any decision made will be placed before the court. Let them take a decision on my application.
My lord, my lord, the learned advocate general will make a submission on 14th. My lord may have it on
14th will consider.
They won't, my lord, do anything, my lord. Matter will just keep
Matter
lingering.
of 4 days. Only 4 days. At 2:30.
Yes.
Lord, I just want to make one small addition. Your lordships referred to para 5 of the order, my lord. There were 2 writ petitions at that time. Para 5 is in the main matter. My case is, my lord, in page 172, where your lordship said same order will follow. I don't want tomorrow them to say I misled or anything, Lord. At page 172, para 5 there, my lord. Order on IA4 of. This is the application by the present writ petitioner. In this, your lordships have said all directions in the previous case will apply. Your lordships may say, kindly say, my lord, read with order on IA number 4 and 5. That's the same date.
Further order was passed in IA number 4, 4-3.
The detailed order, my lord, was passed on IA number 7.
IA number 4, which was by the petitioner herein.
Please.
In which it was inter-alia provided that all the observations and directions passed in the other orders, including order in IA number 7 of 2024, shall apply to the present applicant as the petitioner.
Please.
Full stop. The order in IA number 7 contained the following directions, then quote paragraph 5.
Please.
Obligement.
State, my lord, I can understand this is a PIL, my lord. The state should be anxious, my lord, by this dog in the manger policy.
neither, my lord, workers are getting paid. Entire state, my lord, all mining activity has come to an end in Mysore district. The landowners, my lord, are not getting revenue. Government is not getting revenue. And in cases where there is no blasting, no vibration, nothing is there, they are, my lord, raising such.
It is the size of the industry or the?
It's about 15 kilometers away.
No,
my
no,
lord.
this danger to the safety of the dam is apprehended because of the size of the operation?
Yes,
No,
my lord, that is.
Or nature of operation?
My lord, the argument in the PIL was that there are many mining units in the vicinity of the Krishna Sagar Dam. So they put a thumb room 20 kilometers. So any unit within that 20 kilometers, my lord, court said, don't do any mining. But my lord, the issue is that many of these units are small quarries. They don't use any blasting. They don't use any heavy machinery. They're all hand drills.
You are within 20 kilometers?
Yes, I'm within 20 kilometers, but we are not doing any blasting or cutting. It's all
The
hand.
committee is constituted for this very purpose.
This very purpose.
Yes,
And they,
my lord, now that we have asked for an opinion, my lord, the Indian Institute of Science wants 1 year to provide the opinion. My
No.
lord, and they have charged us 4 crores, my lord.
my lord, they are misconstruing
lord.
everything, my lord.
No, it's not
the,
that.
The issue is this, my lord. Sorry, my lord. The issue is this, my lord. If there is a unit which is doing blasting, let them do all the studies, my lord. Nobody is coming in the way. If there are units which are not doing blasting, they're no explosive. I don't have an explosive license. I don't have a go down for explosives. I only use hand drills, my lord, for cutting these rocks. So in such cases, my lord, the dam safety committee can give, examine, come and visit, because I give a mining plan which is approved by Director of Mines, which says which machinery I'm using, what is the capacity of that machinery. Everything is there. He tells me how to do the mining. All that this dam safety committee will have to, even on paper, they can see, Lord, what is your material you're using, and they can give a certificate saying there's no vibration. I give a vibration certificate also. I don't know why they're dragging their feet, my lord, on
Vibration in the land.
Yeah, no, what they're saying is if there is blasting, that will cause vibration, which will travel up to the dam. What I'm saying is here, my lord, it's a small drill, my lord. Sometimes if there's some electrical short circuit, if somebody comes and drills a hole here, that's a hand type of drill that is operating. That is all the jackhammers that are permitted to be operated. I don't have any fuse. I don't have any blasting material. I don't have dynamite. Nothing is there on the site. It will take them 2 minutes, my lord, they come and see and tell that in this unit there is no blasting that is going on. And the lease says no blasting. Lease itself says.
And not 2 minutes to inspect, 3 minutes to give the NOC to go ahead with the quarrying.
We'll see on.
Yes.
In March, my lord, they said, we want 4 months to give a report in March. Your lordships recorded it. We are now in November. They're still not given a report.
So what decisions the committee is taking?
See, committee, my lord, simply shirks its responsibility. They don't want to do anything in spite of the court order. They say, my lord, that this is not within my purview. When the order is brought to their notice, individual cases they must see. This is how ease of doing business is done in our country, my lord. The state should come forward and solve the problem of the entrepreneur. They're doing everything possible to continue to put spokes in the business. If I can digress, my lord.
We'll see on that.
Obliged.
You just enlighten us.
Yes, ma'am.
Let them take a decision, my lord, on my
That will take a call whether it can be done or not. You produce the.
Yes, my lord.
We have got your area of functioning, but still you produce.
They can't defeat the court's order like this. In spite of the court order, they say we don't have power. We don't do anything.
But then if the court order is beyond the terms of reference.
I would respectfully say, my lord, even then they're bound to obey. My lord, an order passed by your lordship's constitutional court, if they are aggrieved by it, they should come forward, because your lordships will see the context in which that was made was, we approached the honorable court to say kindly permit. Your lordships then delegated and said, let this committee look into it. Now they can't come around and say, we are not going to look into it.
Whatever mechanism you adopt, you should look into it.
Otherwise, my lord, I request the court, my lord, to grant the permission.
We'll see on fourth.
I am obliged.
Cell number 16. It is Sunayana.
This is the petition committee, please.
My lord.
What is?
My lord, they'll have to give a response. Government doesn't appear for the committee, my lord. Notice has to go to them.
Notice has been issued. It has gone to them. Not gone.
We should process your fate now.
Committee must be party.
Yes, my lord.
is
Response number
the
2.
I'm sorry,
Second respondent.
second respondent.
So nobody appears.
Notice has been issued, not subject to correction.
It is issued or not issued?
But
My
we
lord,
have
it
not
wasn't
got any
issued.
report, my lord, sir. I'm
No,
told-
notice is not issued.
I'm told
No, my
notice
lord.
is issued.
My lord, on 24/9, my lord was pleased to issue notice.
It is already issued on
Yes.
24/9.
Your lordships have issued notice.
It's a body.
Lords, it's a petition committee, it's a body, my lords, of the.
R2. Despite notice having been issued by this court on 24/9/2024. And further order passed on 23/10/24. Respond number. One. Two. Committee on Petitions, Karnataka Legislative Council.
You don't even know.
Has not appeared to answer the case of the petitioner. The case of the petitioner and the contentions advanced in the case are specifically addressed to the powers of the committee. In order to enable the committee to appear,
May I make one submission?
we press notice. will issue.
Yes, notice has to be issued because last time government advocate, now she is saying she will not appear for R2. So R2 notice has to be issued. my
Notice
lords.
is issued to the committee, returnable on. When shall we do?
R2 and 3. 3.
R,
I don't appear.
respond 2 and 3, please, returnable on 2nd December,
Very good.
not 2nd December. 5th December. 5th December, please.
Karnataka Legislative Council. we appear.
Service by end delivery is permitted.
Lords, hand delivery, my lords, to the legislative council is.
My lord, unofficially, I'll inform them, my lord.
Interim order granted earlier on 23/10/24 shall continue to operate.
Please,
Full stop.
please.
Obliged, my lord.
Previous matter, notice has not been issued. Sorry. First time it had come up.
Notice is issued.
No, my lord, it's a fresh matter.
The fresh matter.
No, but
also.
today it is,
Yes.
This previous matter, no?
29420.
today it is issued.
Please.
It is returnable on 14.
Cell number 17. Pradeep Sarkar.
Respondent.
For the appellant. Not the direction given by the learned single judge, my lord, is to consider the case of the petition for promotion, the post of principal research scientist in accordance with law as expeditiously as possible and at any rate within. Now, my lord,
Kindly have a look at para 7 and 8, my lord. My lord, the learned single judge proceeds to say that tweaking the rules, she may be considered for promotion, which is not permissible in law. Para 7 at page 40, my lord. May I invite your lordship's attention to para 7 at page 40, my lord. Having heard the learned senior counsel for the petitioner, learned counsel for the second respondent, Indian Institute of Science, and on perusing the petition papers, this court finds, although it is stated in the order dated 4/10/2019, para 7, my lord, the rules relating to, my lord, the promotion and the evaluation has been correctly stated. But then in para 8, my lord, I am asked to tweak them and then grant promotion without looking into it.
It is only a direction to consider the.
My lord, please see, my lord, para 7, what the learned single judge says.
That we have seen.
Yes, my lord. Therefore, my lord, in para 7, this court finds that although it is stated in the order dated 4/10/2019 that the petitioner is required to be evaluated by evaluation committee, and this court is also of the opinion that the second respondent has to follow the procedure prescribed. Nevertheless, based on what has transpired earlier and the reinstatement of the petitioner consequent to the orders or directions given by this court in the previous round of litigation, and the fact that the petitioner has nothing to place before the evaluation committee in the form of a report, which could be reviewed. Since the petitioner's services were sought to be put an end to in the year 2018, and by virtue of the orders passed to the Honorable Court, the petitioner has been able to continue as a scientific officer. The evaluation committee will have to take note of these peculiar facts and circumstances into consideration. Then, my lord, at any rate, the case of the petitioner is required to be considered from 7/3/2009 for promotion to the post of senior scientific officer and further to principal senior research scientist in terms of the law applicable for consideration of such promotion. The resolution, which is pointed out by the learned counsel for the second respondent, if not applicable to the post of promotion to the cadre of the principal research scientist, then appropriate provisions will have to be taken, shall be taken into consideration. The second respondent, ultimately the direction, please say, my lord, is hereby directed to consider the case of the petitioner for promotion to the post of principal research scientist in accordance with law as expeditiously as possible at any rate. Therefore, my lord, first she must qualify for senior scientific officer, and then, my lord, she must do research, and then that research must be sent for evaluation, and thereafter it must be considered. Now, my lord, the learned single judge says you give her double promotion. First promotion is taken as granted. Second promotion, the learned single judge says you grant her without evaluation.
This requires here.
We have filed our reply, my lords. I am for the respondent. There was an.
We'll hear it at
Very well.
some later.
Lordships would like to hear it, my lords. I'm in your lordship's hands.
Yes, yes.
Yes.
On 10th December.
Very well.
As your lordships, please. Please. Lordships may keep it at 2:30, my lords, on the 10th,
On that day, you may request, we'll consider.
because she has now, my lords,
Here
for the
also,
last
we also-
14 years, she has been agitating before this court. Even after her
After the
retirement-
learned single judge's order, my lord, when we implemented it, she did not report for work for 2 years.
No.
And now,
We
my
have
lord,
now,
she
my
has
lord,
completed
withheld- we have
her
started to
service and she
deduct-
has also retired from service.
In
She
fact,
has
there's
retired
a
from service.
contempt petition filed, my lords, because they are
Yes, she
deducting
has also
amount
retired
from
from
her.
service.
All
The
I'm
Supreme Court will have
requesting
to
is
now
it could be
consider
please.
whether that promotion automatically has to be granted and what are the financial benefits to be granted. That is all.
Number 18,
Lordships.
Saurabh RK.
Lords, if your lordships may recollect your lordships memory, my lords. This is the matter which I had argued for some time, and since there were multiple volumes, lords, I had sought for your lordships leave to file, lords, a compilation of convenience. Lords, I have filed that compilation, lords. So that
It was argued.
lordships.
Any further to be argued? Anything further?
Yes, my lords, because I was flipping between the volumes, my lords, so therefore I found that, my lord, there is some inconvenience which I am causing to the court because flipping too many volumes at the same time. So I had myself requested, my lord, that I file a compilation of convenience, which I have filed it now, my lords. If your lords were to take that compilation, lords, I'll quickly try to close my arguments, my lords, in the next 15-20 minutes.
Fifth November file ಆಗಿದ್ದಾರೆ.
May I please, Lords? Lords, Church of South India Trust Association is a company which is incorporated under the Companies Act with the charitable objectives, and this is a minority institution. This is Church of South India Trust is basically, Lords, handling certain affairs of a particular sect of the Christian community. We are having a democratic setup about its management, etc. That's in its place. Lords, prior to Lords, that is during the colonial rule, there were various trusts and organizations of Christian missionaries who had acquired several properties, Lords, throughout the country. Some of the properties, Lords, which was acquired by an entity called as Wesleyan Methodist Missionary Trust Association. Lords, they wanted to wind up this because this was an entity, Lords, which was in London. They wind up their operations and whatever properties were there, these properties were conveyed without consideration in favor of Church of South India Trust. That is a document which your lords will find, my lords, at page number 1 of the page number 2 of the memo. The relevant portion is at page number 3, the third line. This is how the certified copy was given because it is the manuscript. The third line, my lords, in page number 3.
These documents were part of record before learning single.
Yes, all the records, my lords, all the documents which is now produced before lordships as part of the compilation was before the learned single judge. Lords, then your lordships will find the third line. This indenture made this 12th day of June 1963 between Wesleyan Methodist Missionary Trust Association incorporated under the English Companies Act, having its registered office at so-and-so London on one part, and Church of South India Trust Association Company incorporated under the Companies Act, having its registered office at so-and-so. Next para. Whereas the property is more fully described in the schedule here too, have been acquired with the funds of the Methodist Church or have been gifted to it or held for and are under the control of the said Methodist Church, which has been in possession, undisputed possession thereof, and properties are held in trust by the transferor. Notes, I just skip this and come to page number 4. Just to indicate that this is an order of, this is a deed of conveyance. Lords, may kindly see paragraph number 1, minutes. It's almost in the, it's the bottom of the page. Now this integer witnesseth as follows. In pursuance to the above premises, the transferor as trustee aforesaid doth hereby convey and assign without consideration unto the transferor another trustee with the properties set out in the schedule hereunder to hold and to have the properties, so on and so forth. Minutes, I will not trouble your lordships on this. These are the usual terms. Now, if your lordships were to minutes come to the schedule, the first is Bangalore. The peculiarity of description of the properties minutes in the schedule is Bangalore properties are referred as B1, B2, B3, B26, B27. That is how minutes is mentioned. There are properties in Mysore Council area. So far as Shimoga is concerned, your lordships will find at page number 34. I'm sorry, minutes, page number 23. This has some significance. I'm requesting you lordships to just make a note of this. Shimoga Council area is S1, the first property. This is bounded on, your lordships will get the boundaries, Durgigudi extension, Mission Bungalow. This is what is contained there, and then bounded on, north by Main Road, south by Megram Hospital, east by Balancing Rank Road, and west by survey number so and so, old number so and so. This is some significance for the nature of dispute before lordships. I'm just requesting you. Even the measurement, if your lordships were to see, it's a very huge extent of property. This we have made a calculation, it comes to roughly about 11 acres, 30 guntas. Other than this, your lordships will find S2, S3, S4. There are smaller bits of properties which is scattered in that Durgigudi extension. And that is the property which has been described. And your lordships will find it up to S28. There are 28 properties which are conveyed in Shimoga district. Sorry, S30. Now, so far as the properties are concerned, these are the properties coming within the limits of the municipality, the erstwhile municipality. Now, lordships may kindly take notes, page number 34 in this compilation. Notes, I will take your lordships straight away to page 63. Page 34 is the Kannada version. Page 63 minutes. This is the area which is indicated. If your lordships were to see minutes, 95, 96 to 2015, 16, 11 acres, 16 guntas is the property standing in the name of the Church of South India Trust. Page 63. This is so far as the acquisition of title is concerned. There is a title document. We had the revenue entries in our name, cannot be disputed. It is to the extent of about 11 acres and odd. The first instance of dispute which came about, if your lordships may kindly see page number 74 in the compilation. Proceedings were initiated at the instance of a former member of the Mahanagar Palike. He had written a letter on the basis of which proceedings were initiated before the Commissioner Shimoga Bhadravati Mahanagar Palike. This is the proceedings of the year 92-93. May I request your lordships may kindly take page number 99 in this minutes. I'll not trouble your lordships to all the findings. Page number 99. Notice the last paragraph in page 99. But this is by the very authority which is maintaining my khata pertaining to this property. In the documents, the last paragraph, notes in page 19. In the documents produced by the Church of South India Trust Association showing that this disputed place is not CMC place, nor at any time, sorry, notes, page number 99. Sorry. Last paragraph. In the documents produced by the Church of South India Trust Association showing that this disputed place is not CMC place, nor at any time it was a playground, and this place belongs to Church of South India Trust Association, and this place is in the name of Church India South Association, in MK number so-and-so, new number so-and-so is clearly mentioned in the CMC records, and showing that the subjected place is always with the possession and enjoyment of the Church of South India Trust Association, and at any time it was neither public property nor CMC property. And as discussed above, without any room of doubt, it is clear. And not even one document is produced with objective supported argument, as several other documents are not authenticated documents, hence it is not possible to believe them. Let's say categorical finding is recorded that this is not the property belonging to the CMC. Notice then what this person does, if your lordships Milords had observed, there is one Adishesha Milords who had initiated these proceedings. He also gives a complaint Milords to the state government on the basis of which the COD inquiry is instituted. Now that your lordships will find, let's say I produce the translated copy at page number 121.
Hundred and 51.
121, 121, 121. Notice this is the report dated 15/9/94. The lordships may kindly make a note of the date because this is where the whole problem starts for us. Because this report is in our favor, but the proceedings is initiated otherwise. 15/9/1994. The COD submits a report to the Commissioner and Secretary DPR. Notice charge number 2 at page 123 is pertaining to the present property. The Church of South India Association in Shumaga Commission compound in Nagarpalike 10 acres of land has not taken into account the public protests have formed the layout on sold sites.
Page number 120.
123 charge 2.
Charge 2.
Yes.
What is this charge? Charge 2?
The charge is not this property, which is about 10 acres and odd. We are trying to form the layout and sell the sites on the basis of an illegal khata, which is standing in our name. This is the charge. That charge will not, there is a detailed observation which is made at page number 125. And what is very, very essential, Milords, is the report takes note of the registered document which I referred to, Milords, at page number 2, at page 126. The same boundaries and all is taken note of. And ultimately, Milords, what is observed is at page 130.
We'll continue.
Lordships.
Court officer? Court officer?
My lord. My lord. My lord, I apologize to my lord. This morning, no, my lord, it was the wrong information that I had received based on which I made, I apologize, my lord. I didn't mean to. I apologize. I apologize. I'm obligated.
This is number 18.
That's page 130, my lords. First paragraph. May just read that one paragraph, my lords. This is the contents of the COD report. In this regard, the application of Adishesha and Sampath is handed over to the Commissioner CMC. The Commissioner, on going through both the parties' documents, have heard the arguments. After deep hearing, the Commissioner CMC coming to the conclusion that the said vacant site is not the Mahanagarapalika property, and I opined that the said property belongs to CSI Trust, and hence applications were dismissed, have issued an order dated so-and-so. The said inquiry report is collected and submitted for perusal. As a complaint in the application, the said vacant site does not comprises in the 10 acres, and the Adishesha with regard to this land belongs to CMC. I have not produced any documents in this possession. Notes, having said this, the conclusion, my lords, is at page 133.
Yes.
Lords, totally with regard to the COD inquiry, charge 1, 4 and 12 is proved. Charge 2 is not proved. Lords, that, I'm sorry, my lords, I had to take your lordship's attention to bottom of page 131. This is very important, my lords. The last paragraph, page 131. The allegation that the CSI Trust Association in Shimoga Mission Compound CMC are making layout and selling sites is not true. Applicant claiming that the land belongs to CMC and the said land belongs to CMSMI Trust Association. Said land is in possession and enjoyment of the CSI Trust. And further, the assessment register is entered in Khata number so-and-so. And the CMC themselves say that the said land is not CMC land. And hence, with the above materials, the allegation and charge is not true. Notes, having said this, there is one small degree copy. The missive now starts, actually. The order is in my favor. COD report is in my favor. Now, lordships may kindly take annexure, that is page number 137. This is where the problem starts for me. What's the this letter is dated 28/38/2004. That is missing, lords, in that 38/2004. Your lordships will find the reference is to the report of the COD dated 15/9/1994. But the contents is, during the earlier Shimoga Bhadravati Mahanagarapalika limits, in 10 acres of land belonging to CMC, the mission compound, the Church of South India have unauthorizedly formed a residential area and have sold the sites. On the basis of false documents in Shimoga CMC, the documents Khata being registered to verify as per the rules and to cancel the Khata and to take action, desire to submit a report and report the doctorate. There's absolutely no basis for this except for the COD report dated 15/9/1994. 15/9/1994 report is the one which is in my favor. Now, the authorities now wants to initiate action in the year 1994 on the premise, in the year 2004. It's after a lapse of almost like 10 years, 15/9/94 is the date on which the COD submits the report. 38/20/2004 is the date on which a notice is issued by the Director of Municipalities to the Municipal Commissioner CMC Shimoga. This stems the dispute pertaining to the khatas which were existing till 2004 also. But on this basis, what they do, lordships may kindly now take page 138. Not some unconnected parties. Adishesha is the person who is repeatedly been representing who happens to be the former CMC member. If your lordships were to take, my lords, page number 138. Lordships will find petitioner is one Yesudas, President, Advocate, Christ Federation, Shimoga. Adishesha, former CMC, these are the two parties. Lords, Church of South India Trust Association is not a party in these proceedings. Now, the Deputy Commissioner entertains a petition, this letter. On the basis of this letter, Lords, he takes this forward and then passes an order, which your lordships will find, my lords. The operative portion of this order, lords, is at page 151. This reasoning, my lords, may be of some relevance. At page 151, note the second, the last paragraph in page 151. As seen in that inquiry, the charge number 2 is that the Shimoga Mission Compound, Church of South India Trust Association, Shimoga, belonging to Mahanagarapalike, 10 acres and land not bothering to public protest, have formed the layout and sold the sites, and the transfer of khata has come before the Mahanagarapalike with regard to the plot and municipal documents. In view of the alienation of this Mahanagarapalike, huge losses caused, and have released the deputy mayor has attempted to close this case. After the detailed inquiry for charge number 2, inquiry in mission compound belonging to Mahanagarapalike about 10 acres of land is done and the sites are being sold, have released that the mayor and deputy mayor for issue of khata to the purchasers of the site have come forward with regard to alienation at the time of hearing. When Mahanagarapalike register was seen, Church of South India Trust Association named during the current year khata number so and so was there. Notes, having said this, they again extract notes in the bottom of this page, continuing at page 153, the schedule which was mentioned in the 1963 document. And the last minutes, if your lordships were to take page 153, after the schedule, the dispute place is adjacent to the playlasting road towards the west and towards the north is 230 and 232 and 269. The vacant plot, which converted into sites, is adjacent to Tungbhadra Sugar Factory house towards the east. And in this place, Church of South India Trust Association have formed 12 sites. And to the said layout, the commissioner layout have granted the approval on 24/1/1991. Notes, their betterment charges is collected, so on and so forth is extracted, and then may take your lordships notes to the operative portion of the order at page number 158. At page 158. In this case, Director of Municipalities letter dated 30/2004, which I now read to your lordships, directions to implement as it is, order passed by the Municipal Commissioner, CMC Shimoga. Notice what happens. The order is in my favor. COD report is in my favor. The proceedings are closed in 1994. 2004, the Director of Municipal Administration writes a letter saying that there is an illegal khata formation or illegal site formation. You look into the matter. Deputy Commissioner says, you implement the order dated 38/2004, in which I was not a party. Then what I do is, I again go before the Deputy Commissioner, Church of South India Trust. At page number 162, my lords, the typed copy. Page 162, I go before the Deputy Commissioner. But this is just a connecting document only to say, the Deputy Commissioner says, since I have already passed an order, you go and approach the higher authorities. At page number 164. But since this order was staring at me, I preferred a writ petition in WP number 372232 of 2011 before this honorable court at page number 165. The findings in this matter, my lords, virtually concludes what is the subject matter of the controversy in this list. Lords, may kindly take page 165, my lords. Lords, at page 175 is the findings. May read para 11, my lords, if it permits me. At page number 175. Having heard the learned counsel for the parties, it is a specific case of the petitioners that the Wesleyan Missionary Trust Association and Executive Trustee as per Annexure D in favor of so and so. Since then, the petition has been portion enjoyment of the properties have assigned been different khata numbers as stated supra. It is also not in dispute that the petition association has sold sites formed by the petitioners as per Annexure G and H in favor of third parties. It is also not in dispute on the complaint made by fifth respondent Adishesha along with one M. Sampath. Jurisdictional Commissioner Shumaga Municipal Council registered a case number so and so after holding detailed inquiry and after hearing both the parties by a detailed order on 21/193 held the present petitioner Church of South India Trust Association is the owner of the properties in question based on the documents produced, and the said properties do not belong to the municipality or the public properties. Therefore, the objections by the fifth respondent and other was rejected. The said order passed by the third respondent, Commissioner of City Municipal Council, who is the jurisdictional authority, has attained finality. Though, this is very important, though the learned counsel for the parties sought to justify the properties belong to the government, it is not the case of the state government or the Tahsildar either before the deputy commissioner or before this court that the property belongs to the state government. Paragraph number 12. Even if it is the property of the state government, this also has some significance. Even if it is the property of the state government, authorities have to give an opportunity of being heard to the aggrieved affected party and then has to proceed to pass the orders. Even though the learned counsel for the respondent sought to justify the deputy commissioner had given an opportunity to the petitioner, it cannot be accepted merely on the ground of Annexure F, and the order passed by the Commissioner of City Municipal Council clearly depicts petitioner was a Church of South India Trust Association represented by PI holder Vijay Kumar Dandin. Fifth respondent was first respondent and MP Sampath second respondent. According to Prasad, the learned counsel was respondent by Yesudas, chairman and president of CSITF, are one and the same, as the same petitioner did not produce material stock before the court to show that the present charity is so and so. Now, having said this, then paragraph number 14. A careful perusal of the order at Annexure A clearly depicts that the deputy commissioner has not issued any notice or an opportunity of being heard before passing the impugned order. Though the review petition came to be filed by the petitioner, which came to be dismissed on the ground, he has already passed an order which amounts to res judicata. Specific contention has been taken by the present petition before the deputy commissioner that the first respondent is not the authorized petitioner. And ultimately, this honorable court at para 15 has remanded the matter for fresh consideration to the deputy commissioner. At page 180, the bottom, the last paragraph. Then what happens? The jurisdiction has been shifted from deputy commissioner to the regional commissioner because of the change in the nature of the urban body. Now the regional commissioner passes an order, which your lordships will kindly find at page 183. They translated. My sincere apologies, may just request, it appears that one translated copy is missing in the compilation minutes. Annexure A at page 115 minutes in volume 1. This is one document which is 115 minutes in volume number 1 minutes in the main writ appeal papers. This they have produced only the Kannada version minutes. The English version is not produced. Translation. Hmm. 16,722. 13,721. This is translated copy there. I'll just. None notes good. $683. Yeah. Volume 3, 683. Main dilva. Advocate letter and extract.
ಸಾಗಿಸ್ಬಿಡೋದಲ್ವಾ ಇದನ್ನ ನೀವು ಇಷ್ಟೊತ್ತಾಗ್ತೈತೆ ಇನ್ನೊಂದು ಸಾಗಿಸಕ್ಕೆ ಅದಕ್ಕೆ ನಾನು ನಿಮ್ಗೆ ಹೇಳಿದೆ ದಿಸ್ ಇಸ್ ವಾಟ್ ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಇಟ್ ದಿಸ್ ಇಸ್ ವೇರ್ ವಿ ಆರ್ but there is some lapse on the part of the council that he has produced only the translated copy of annexure of the covering sheet of the order at page number 682. I'll just read this and then I'll explain what is there in the contents of the regional commission's order which was impugned in the writ petition. At page number this letter is at page 187. I'll just read this, on the basis of instructions along with the connected record of the corporation relating to the properties claimed to belong to Methodist Church and further claimed to have been made over to the Church of South India, we appeared for the corporation. Final arguments were heard by the Regional Commissioner, Bangalore Region, and reserved for orders. I am glad to inform that the Regional Commissioner, Bangalore Region, has accepted our arguments and by order dated 13/7 dismissed the revision petition. Regional Commissioner, Bangalore Region has further held that rival parties, Church of South India, President Church Union, Shumoga, may establish the right to the disputed property before appropriate civil court. Until such time, the corporation shall maintain and make necessary entries as per the decision of the civil court. Regional Commissioners further directed Church of South India not to create any form of incumbency in respect to dispute property. Copy of the order of the Regional Commissioner is received by us so-and-so. Now, this is the covering letter. The document itself, 16/7/21 is the date on which the order is passed. I'll just explain what this order says. The order does not record a finding that this property belongs to municipality. This is very, very important. What the order only says is that the title of my vendor, Wesleyan, which had conveyed the property to me in the year 1963 is not made out. Therefore, you are required to go before the civil court, establish your title of your vendor of 1963, and then come back. Till such time, we will maintain status quo regarding the entries by making a specific reference in the entries that this is the order passed, number one. Secondly, you are required to maintain status quo relating to this entire property and not to create third-party rights. This is the order which was passed by the Regional Commissioner. There is no finding in this regard that this property in any manner belongs to the corporation. Now, this dispute ended there. This is on 13/7/2021. That is the date. This is challenged, in WP number 16866 of 22. Translate copy then. Okay. But then the problem starts only here, my lords. Kindly have a look at page number 213, 214. The translated copy, my lords, is at page number 215. This is on 16/7/22. This is very, very crucial. This is where a property which was never standing in the name of the corporation or never was it a government property, since it was a vacant property, they say that since there is a vacant piece of property is there available there, therefore we are directing this khata to be made out in the name of the corporation. That is the document which is dated 16/7/22 at page number 215. What's the demand? That is what it says. The demand, yes. Site number marks PLO number so-and-so, Director Sim Shumaga, dated so-and-so, Worshipful Mayor, dated so-and-so, general meeting held by the chairmanship of the commissioner on 5/7/22 and on 31/5/22 as per the Honorable DC letter, Shumaga, dated so-and-so, land surveyor and Mahanagarapalike surveyor spot inspection report and rough sketch site section report basis, Shumaga Taluk Kasba Hobli, Maligata Gram Thana, 2 acres, 35 guntas land is recorded and registered as the property of Mahanagarapalike. Lords, I'll just read the Kannada version also, my lords, so that it will give some at page number 215. Your lords, may kindly see for a moment, my lords. I'll just read this.
ನಿವೇಶನ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ನಿರ್ದೇಶಕರು ಶಿವಮೊಗ್ಗ 215. ನಿವೇಶನ ಸಂಖ್ಯೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ನಿರ್ದೇಶಕರು ಶಿವಮೊಗ್ಗ ವೈದ್ಯಕೀಯ ವಿಜ್ಞಾನ ಸಂಸ್ಥೆ ಶಿವಮೊಗ್ಗ ಇವರ ಪತ್ರ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಮಹಾಪೌರರ ಟಿಪ್ಪಣಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಸಭೆ ದಿನಾಂಕ ಸೋನ್ಸೋ ಜಿಲ್ಲಾಧಿಕಾರಿ ದಿನಾಂಕ ಸೋನ್ಸೋ ಭೂ ಮಾಲೀಕರು ಮತ್ತು ಮಹಾನಗರ ಪಾಲಿಕೆ ಸ್ಥಳ ಪರಿಶೀಲನಾ ವರದಿ ಹಾಗೂ ಕಚ್ಚಾ ನಕ್ಷೆ ನಿವೇಶನ ಸಭೆಯ ವರದಿ ಆಧಾರದ ಮೇರೆಗೆ ಶಿವಮೊಗ್ಗ ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ಮಿಲ್ಗಟ್ಟೆ ಗ್ರಾಮತಾಣ 2 ಎಕರೆ 35 ಗುಂಟೆ ಪ್ರದೇಶ ಮಹಾನಗರ ಪಾಲಿಕೆ ಆಸ್ತಿ ಎಂದು ದಾಖಲಿಸಿದೆ. Not the reason why I am submitting this is for the first time a recording is made that this vacant piece of property is the Mahanagara Palike property on 16/7/2022. This is an endorsement on 16/7/2022. On the same day, the property is handed over to Sims, saying that this is the property belonging to the Mahanagara Palike. Now your lordships may kindly see the last of the documents produced. At page 261, the allotment letter, my lords, which they claim, handing over of the site certificate. At page 261, they describe what is this property. Your lordships will find East by Community Hall of St. Thomas. Lord, that is a CSITA property. St. Thomas Hall is there, that's a CSITA property. Lordships may kindly marks West by survey number 17. North by road, South by Megon Hospital premises. If your lordships were to juxtapose this schedule to what is contained in page number 23, then there is another sketch which I'll take your lordships to, but just to juxtapose these two schedules, my lords, to indicate there could not have been any dispute relating to the identity of the property. It was well described by the identified boundaries. Your lordships will find, my lords, in page number 23, lords, if it is juxtaposed, north by main road, south is, there is it is Megon Hospital, my lords. Megon was one of the erstwhile commissioners of Shimoga. He had established a district hospital. So it is in his name, the Megon Hospital is functioning even as on today. That's called as Megon Hospital. In the schedule which is given to S1, my property, West by survey number 17, South by Megon Hospital. If two boundaries are established, it is not necessary for me to establish the other boundaries, but still, your lordships will find north by road and south, my lords, in the letter which they have given is my property. Exactly the very same property for which the orders have been passed, COT report has been passed. Now, everything being in my favor, a letter is generated in the year 2004 saying that you implement this order saying that these are all illegal khatas which has been effected. Then my problem starts. This honorable court records a categorical finding that the state has never taken a stand. This belongs to the state government. The municipality has never taken a stand that this property belongs to the municipality. For the first time on 16/7/2022, saying that there is this vacant piece of property available, we are directing this property to be registered in the name of the municipality. And on the same day, the property is sought to be handed over in favor of Sims. 16/7/22 is that critical date, is the muhurtam date, when everything takes place on one single day. The registration of khata and the property being allotted in favor of Sims. This is, my lords, just if I can just give an example, my lords, it is a vacant land in the middle of the city. This city virtually is around this mission compound. Now, this is the heart of the city. This 2 acres, 35 guntas. It is not, it's some corner that there is no earlier municipal records. It is not like that. This has been under the municipal administration for at least over 100 years. And this is the property where they say for the first time that this property becomes a municipal property in the year 2022. And that is how, my lord, Sims wants to step into my property. This is where it stands. Lords, now just one more aspect, my lords, which I'll have to take your lordships to. A decree on Purpuri. But there is a sketch which was part of the suit which I had filed. Lords, only to indicate, lords, what boundaries is referred to. Decree. 767. Page number 73, my lords. Full sketch ಕೊಟ್ಟಿದ್ದೀರಾ? So, it's page 73. What's this bottom portion? There is a long vacant piece of property in the bottom portion. It could get. Lord, this is facing north. The sketch is facing upwards is north. Lords, on the west is that reservoir and survey number 17, which is exactly what is tallying with what has been mentioned, my lords, either in my 1963 document or in the allotment letter which is given to them, or the site handing over. West is that reservoir and survey number 17. And the bottom of the page, your lords will find Meggan, MEGGAN. Bottom of the page. It continues, Meggan Hospital premises. Sorry, my lords. Bottom of the page is the southern portion, Meggan Hospital premises. And survey number 17 and reservoir is what is on the west. Then on the east, my lords, your lords will find there is something marked as P96, OS number 135 of 59.
We don't have the space for two.
I'm sorry. It's marked as P9B. Lords, that is, if your lords were to see from the top of the page on the right hand side, P9C, P9B, and bottom is P9A. But this was the subject matter of the suit. OS number 135 of 1959. This is the periphery of my property. Notes, beyond this property, there are several developments which has come about.
Map also subject matter of suit.
This was the subject matter of the suit. This was marked. There is a significance to this map because subject matter of this suit was this strip of property because there was an encroachment by the municipality. Notice on the right hand side, which is forming the eastern side, are the properties which are belonging to the municipality. They had encroached into my property by around 8 feet to 9 feet. From top to bottom, about 9 feet they had encroached throughout. So that was the subject matter of the suit. Now I have demonstrated, my lords, this entire sketch, reservoir and survey number 17 are adjacent properties which they have themselves admitted by virtue of issuance of that site handing over letter. On the south is Meggan Hospital. North, your lords will find that there is a road which is running throughout. Before the sites, just down below the sites, there is a road running throughout. So this road and survey number 17, Meggan Hospital, 3 sites are completely. And the 4th site is concerned, I am not in a position to say anything more to beyond this to say that the 4th site that is on the eastern side was subject matter of a civil suit in which the civil suit has decreed the suit in my favor, holding that this is the area which they wanted to encroach. Now, in that, I had referred to the schedule on the last occasion, I'll not be repetitive. If your lordships were to recollect, in this suit, the description of the property is towards the west is the property of the plaintiff, that is the CSITA. It was my vendor's property which was reflected. This is how clearly we have established the case. Now, having done this, we challenged it before the learned single judge. This is essentially what we argued before the learned single judge. The learned single judge says, this is all produced before the learned single judge. The learned single judge says that there appears to be a dispute regarding identity of the property.
Concluding by 3:30.
I'll conclude. In another 2-3 minutes, I'll conclude.
All the friends are waiting.
I understand, my apologies. There are some judgments which I have to. I'll quickly read it. I think in another 9 minutes, I'll finish it. This. The learned single judge principally holds that there is some disputed question of fact which is emanated in the manner in which the respondents have presented their arguments. Number one, the point for consideration itself is as to whether this question should be gone into under 226. And the court answers that there appears to be some dispute regarding identity of the property. Therefore, it is appropriate to relegate the parties to the civil court. This issue has already been decided. It's not once, twice over it has been decided, and there is no requirement of a further decision in the matter is my case. But just to run over the decisions which I want to rely upon. First and foremost decision which I want to cite is this. State cannot be a land grabber. Though, my lord, this was a judgment in the context of whether the state can come up and plead the equities in the nature of adverse possession, etc. But the principle which was evolved, my lords, in this judgment is with the state of Haryana versus Mukesh Kumar. Para 45, my lords, just 2 sentences which I'll read. The effect of such an exercise, my lords, to be undertaken. Para 45, just 4 lines in that I will read it. Last page, notes of this judgment. If the protectors of law become the grabbers of the property, land and building, then people will be left with no protection and there would be a total anarchy in the entire country. It is indeed a very disturbing and dangerous trend. In our considered view, it must be arrested without further loss of time in public interest. No government department, public undertaking, much less the police department, should be permitted to perfect their title or land by adverse possession by invoking provisions of adverse possession and grab the property of its own citizens in the manner that has been done in this case. Notes, of course, here they wanted to claim a longer possession of the property, but in the present case, what is very startling is it comes into existence in the year 2022 in the heart of the city for the first time, saying that this is a property belonging to the municipality. Then, my lords, I will refer to Hope Plantations versus Taluk Land Board. Notes, on the principle that if issues have been decided with the participation either in exercise of quasi-judicial powers or even administrative powers and the findings therein are recorded, it would not be permissible for the government to go beyond the findings which was recorded in the earlier proceedings. Notes, first year was my apologies, he's given a wrong judgment. My apologies.
It is a cost of long argument.
Page para 45 minutes. Last page, minutes in this. Page number 419. Last Lecitum G. If the protectors of law become the grabbers of the property, land and building, then people will be left with no protection and there would be total anarchy in the entire country.
It is indeed a very disturbing and a dangerous trend. In our considered view, it must be arrested without further loss of time. In the larger public interest, no government department, public undertaking, much less the police department, should be permitted to perfect their title of land and building by invoking provisions of adverse possession and grab the property of its own citizens in the manner it has been done in the present case. It's on an equitable principle where there was a long-standing possession for about 20 years. The government wanted to take a stand that no, we have a title over this property for over 20 years. But here is a worst case on hand, my lords. 16/7/2022. They say that this property belongs to us and they want to deal with the property number one. Not the judgment which I have already referred, judgment which I have now given, my lords, Hope Plantations case, para 26, my lords. Lords, at page 607 of this judgment, para 26. It is settled law that the principles of estoppel and res judicata are based on public policy and justice. Doctrine of res judicata is often treated as a branch of law of estoppel, though these two doctrines differ in some essential particulars. Rule of res judicata prevents the parties to a judicial determination from litigating the same question over and over again, even though the determination may be demonstrably wrong. When the proceedings have attained finality, parties are bound by the judgment and are stopped from questioning it. They cannot litigate again on the same cause of action, nor can they litigate any issue which was necessary for decision in the earlier litigation. These two aspects are cause of action estoppel and issue estoppel. These two terms are of common law origin. Once again, an issue has been finally determined. Parties cannot subsequently in the same suit advance arguments or adduce further evidence directed to show that the issue was wrongly determined. Their only remedy is to approach the higher forum if it is available. Determination of the issue between the parties give rise to, as noted above, an issue estoppel. It operates as in the subsequent proceedings in the same suit in which the issue has been determined. It also operates in the subsequent suit between the same parties in which the same issue arises. Section 11 of the Code of Civil Procedure contains the principles of res judicata, but these are not exhaustive of the general doctrine of res judicata. Legal principles of estoppel and res judicata are equally applicable in proceedings before administrative authorities as they are based on public policy and justice. But this is why what I am referring to is that the proceedings of the year 1993 and the civil suit, which is already decided that this entire property is belonging to me, is what I am submitting. Not same is para 24, my lords, in Abdul Quddus case. It's on the same principle. This is para 24, my lords, with a little, even if it is a quasi-judicial tribunal, it doesn't mean that the principles of finality cannot be attached, is the principles discussed by referring to Ujjambai's case. Para 24 at page number 616. The opinion or the order of the tribunal or the order passed by the registering authority based upon the opinion of the foreigners tribunal, as the case may be, can be challenged by way of writ proceedings. Thus, it would be incorrect to hold that the opinion of the foreigners tribunal and or the consequential orders passed by the registering authority would not operate as res judicata. Both the opinion of the tribunal and the order of the registering authority result in determination of rights and status of under the statute and by an authority under the contest on the merits which would necessarily operate as a part of the subsequent proceedings before the same authority for determination of the same issue. The court in Ujjambai has held the principles of res judicata equally apply to quasi-judicial bodies. Whenever the principles of res judicata equally apply to whenever the judicial or quasi-judicial tribunal gives a finding on fact or law, its findings cannot be impeached collaterally or in a second round and are binding until reversed in appeal or writ proceedings. Characteristic attribute of a judicial act or decision is that it binds, whether right or wrong. Thus, any error either on fact or law committed by such bodies cannot be controverted, otherwise by way of an appeal or writ, unless the erroneous determination relates to jurisdiction of that matter, etc. Not same is Banu Kumar Jain's case. Not in that only one small paragraph, para 32 minutes, a little different way of presenting the same principle. It's para 30, 29 and 30. I will not trouble your lordships. It is referring to Thode versus Thode, which describe the doctrine of the issue estoppel. But para 32 is what I will read. At page number 798. The said dicta was followed in Barbaros, Staffordshire County Council. A cause of action estoppel arises where in two different proceedings identical issues are raised, in which event
The latter proceedings between the same parties shall be dealt with similarly as was done in the previous proceedings. In such an event, the bar is absolute in relation to all the points decided, save and except the allegation of fraud. So, Lords, whatever has already been decided is something which can never be, Lords, gone beyond. Lords, then the other judgment, Lords, is on the principle which I have referred to, Lords, the first judgment, para 35. In BK Ravichandra, para 35. But this was also dealing with the property rights. I'll have to advance one more argument, but para 35 minutes, this is what it says. It is therefore no longer open to the state in any of its forms, executive state agencies or legislature, to claim that the law or the constitution can be ignored or complied at its convenience. The decisions of this court, the history of the right to property show that though its preeminence as a fundamental rights has been undermined, nevertheless, the essence of rule of law protects it. Evolving jurisprudence of this court also underlines that it's a valuable right ensuring guaranteed freedoms and economic liberty. Phrasing of Article 300 Captain A is determinative and its resemblance with Article 21 and 265 cannot be overlooked. They, in effect, are a guarantee of supremacy of the rule of law and no less. To permit the state, whether the union or the state, to assert that it has got an indefinite overriding right to continue occupying somebody else's property, bereft of lawful sanction, whatever be the pretext, is no less than condoning lawlessness. The court's role is to act as the guarantor and a jealous protector of the people's liberties, be they assured through the freedoms, right to equality and the religion and cultural rights, part 3, or the right against deprivation in any form, though any process and other law. Any condemnation by the court is a validation of such unlawful executive behavior, which it then can justify its conduct on the anvil of some loftier purpose at any further time, aptly described as loaded weapon ready for the hand of any authority that can bring forward a plausible claim of an urgent need. That's what it said. But I will not, again, Dev Sharan is also on the same principle, Milords.
One more.
Milords, it's on the same principle, Milords. I will not. Milords, just one more sentence which I wanted to add, Milords, having said this, Milords. Milords, so far as I opened my arguments by saying that Church of South India Trust is an organization of the minority institution. Though the right to property, Milords, was abridged because of Article 19(1)(f), Milords, being deleted from the Constitution, but the right to hold the property by a minority institution such as the Church of South India Trust still remains a fundamental right under Article 26 of the Constitution. We are now seeking to Milords, protect the fundamental rights which is enshrined under Article 26. Question of relegating us back to the civil court to determine my fundamental right doesn't arise. The moment I am a minority institution which nobody can dispute, there is a larger responsibility, Milords, under the scheme of the Constitution itself that my rights requires to be protected. If this is the manner in which the lawlessness seeks to be inflicted upon us, saying that, all right, there is a vacant piece of property, we want to take over the property, you go and hang yourself in the civil court, is not the manner in which the Milords, the authorities could have treated us. The learned single judge, Milords, clearly misses out on this, saying that this is like any other civil dispute, Milords, would not have been justified. More particularly when the earlier civil dispute is already decided in my favor with the clear boundaries and the sketch which I have now referred to, Milords, before your Lordships. I'm grateful for the hearing, Milords.
My argument at a time where my learned senior can stop to say. I will only refer to the document or start my argument with the reference to the document through which they claim that they have the title, Milords, in the compilation of the complaints which they. I'm sorry, Milords. I'm so sorry.
Not today, no.
Please, I'm sorry. I didn't realize that. I'm sorry.
Because your friends are waiting.
Please.
Board is not only half.
The short date would be only.
Tell your date and we'll keep on that. 15th?
15th, Milords, yes, Milords.
Or any other date?
14th, 13th, any day.
No, not on
14th, 13th, some matters.
15th.
Would it be on 19th, Milords?
Milords, we have undertaken not to construct.
Pardon?
We have undertaken not to construct, Milords. There is some difficulty because the escalation of prices is what we are worried at.
Completed.
I'm sure, Milord. Please, Milord. 19th also, I'm okay.
19th.
19th.
Please, please.
There's an order, Milords, interim undertaking requires to be extended. Please, Milords, great.
Yes.
Passover matter. Seal number 2,
Lord,
to KV Narasimha.
kindly have this matter, my lord.
My lord,
I have this matter after 22nd, my lord. I'll get an affidavit filed, my lord, complaints affidavit.
22nd.
Please, after 22nd, my lord.
we have,
After
we have-
Please, my
26,
lord.
26.
Very well.
Send out to 26 as a request of learned tradition government advocate. Sir. Mr. Harish,
maybe
in order to
disposed of, my
enable
lord.
him to file reply.
Maybe disposed of, my lord. Even we have received the notice.
Pardon?
We have received the notice from the respondent, my lord, in respect of date, fixing a date.
My lord, the
Even maybe-
direction, my lord.
So it is to be disposed of,
Maybe disposed of.
to be disposed of.
Yes. We have received the notice of fixing the date, my lord. My lord, writ petition is filed seeking a writ of
You
mandamus.
have received the notice.
My lord,
You have received the notice.
we have received the notice.
Learned
Lord, a
advocate
hearing is scheduled on
also
22nd, my lord, therefore.
stated that the petitioner has already received notice. In that view, it could be concluded that the directions are under process of compliance.
In the process of complaints, my lord, because we have issued a notice scheduling the hearing on 22nd November, on which date the review will be decided, my lord.
Yes, my lord.
As the petitioner will be heard and the necessary decision taken within the reasonable time, the present contempt proceedings are not required to be continued, they are disposed of. Yes.
Serial number 110.
Lord, in this matter, my lord, on last occasion, my lord,
Yes.
My lord, this is the appeal by the employees PF organization.
Yes.
yeah, last occasion, lordship wanted me to appraise the court if a writ appeal has been filed, my lord. No writ appeal has been filed, my lord. There is a small mistake in the translation, English translation, my lord. The order has been complied, my lord, subject to certain conditions. Lordship will find page number 14, my lord. Condition number 1 is there, my lord. The order was complied, saying that.
Not for complaints.
110.
Writ appeal.
I'm sorry.
Who appears?
I beg to appear for the appellants, my lord.
Yeah.
I beg to appear for the appellants in 110, my lord.
You appear here, you are visible, but
In fact, my lord had specifically directed that the matter would be disposed of today, I mean, for final arguments in their presence.
who appears?
To BC Prabhakar, Mr. Kumar MN.
Why you have come?
Mr. Kumar is for the central government.
I'm
He's-
for the central one. So
so he's
sorry.
for the, he is for the central government. He's for the pro forma respondent. The contesting respondents.
I make only one submission. This is a notification issued by the central government.
If you are not contesting, then don't argue. Are you contesting this one?
Around-
Let somebody come.
Both of us sailing the same this thing. We are also going to file appeal. We'll get it connected. Will you file the appeal in a day or two?
29.
29th. Please. No, sorry, I got late.
Serial number 112.
Obliged, my lord.
Mr. KV Narasimhan. A complainant, my lord. My lord, liberty may be reserved. Liberty may be reserved to challenge the endorsement, my lord.
In this,
Yes, my lord.
so you are withdrawing.
My lord, liberty, my lord, because they have filed the affidavit, my lord, we have received the copy of affidavit, my lord, that they have complied with the order.
Please, my lord, an affidavit has been filed, my lord.
The direction of learned single judge in his order dated 9th November 23 was to decide the representation made by the petitioner. Today, when the contempt proceeding came up for consideration, learned additional government advocate produced compliance along with which Also produced was the endorsement of the order dated 13/5/24, deciding the representation. Full stop. Learned advocate, paragraph. For the complainant could not dispute the factual position that the representation is decided as per the endorsement. He hours requested, paragraph, that liberty may be reserved for the petitioner to challenge the endorsement on merits. Full stop. Such liberty is reserved. However, the contempt proceedings are closed as not survivable.
Published. Serial number 113.
Such liberty is reserved without expressing any opinion on merits. Full stop. Paragraph, next paragraph. The contempt proceedings are closed.
Repeating for R6, ma'am.
Pardon?
Respond number 6.
Serial number?
That complaints affidavit has been filed, my lord.
Lordship, in this matter, complaints affidavit is filed, my lord, in the Kannada version of the complaint of order, your lordship, in condition number 1, your lordship, some
No writ appeal is filed. in
conditions
this
are.
matter. No writ appeal is filed, my
writ
lord.
appeal-
Order has been complied by issuing one condition is there, my lord, page number 14, my lord. The English version would say, my lord, that a writ appeal is filed. But the correct, it is not the correct translation, my lord. The Kannada version,
that-
Kannada version would say, my lord, that an appeal to be filed, my lord, in case an appeal is filed. But by mistake, my lord, the English version says the appeal is filed, my lord. Position stands clarified in view of the Kannada version, my lord.
Appeal is not.
No appeal is not filed, my lord. It only says in case an appeal is filed.
So what you will do now? You will comply with?
that
Order has been complied, my lord.
Complied with.
That condition may be, your lordship.
There was ambiguity regarding the condition.
Condition number 1 may be, your lordship, some correction is there, your lordship. Let's see.
Page 16, the Kannada version.
On
condition.
4/11/24, following order was passed by the court and court this order of 4/11/24. Today, when the proceedings came up for consideration, learned additional government advocate fairly submitted that condition number 1 mentioned in the order was wrongly translated inasmuch as the appeal has not been filed.
Not filed.
However, it is not in dispute among the parties that the order under contempt is complied with. In that view, nothing survives in the proceedings. The petition is disposed of by covenant.
Serial number 114. Giri Kumar SV.
Appear for appellant.
Respondent, complaints affidavit has been filed.
My lord, complaints affidavit has been filed and it's a wrongful submission which has been made. I will file my rejoinder to that affidavit.
What is the direction? Let us see.
Yes, my lord. Direction is at page 15, my lord.
So representation is decided.
Please,
What is this, your compliance affidavit?
sorry, my lord.
You are arguing
Yes, my lord.
through mobile.
No, it's not my phone.
Yes, where is the compliance?
I have submitted it.
Where is your
18/7.
compliance affidavit?
18/7. I submitted on 18/7, filed in contact.
18th of
18/7.
3810 is there. So what you are saying?
Lord, I have considered the representation, my lord. They have given endorsement that, state government endorsement, my lord.
Where is that endorsement?
You have produced, my lord.
Dated 3/11? No,
30/10, my lord.
3810.
2024. They have produced 2 endorsements, my lord. They have challenged the said endorsement in another expedition, my lord, which is pending before the, this single loan judgment.
That is there, my lord. My respectful submission is this, my lord. The facts of the case is this, my lord. I'm physically and mentally handicapped, my lord. I am the headmaster of a challenged school, disabled school, special school, my lord. From 2015, my lord, they say the allegations, but they have not taken him into me service, my lord.
Where is your endorsement?
My lord,
Pass it.
endorsement.
So it is lying with you.
In his statement of objections, my lord, page 5, my lord. Page 5, the English translation. They say it in the name of a certificate.
This is there. This is of 3/11/23. But you are saying 38/10/24. Where is your endorsement?
My lord, this is complaint affidavit, my lord. Endorsement was issued by them, my lord.
You have complied with?
Yes, my lord.
So by what endorsement you have complied with?
Consider the single judge, single judge that directed us to consider the representation, my lord.
Directed you to decide the representation.
Yes, my lord.
So where is that?
I filed, my lord.
Simple thing you are not answering. Yes, please. This is not available. Where is the endorsement?
He has not given any endorsement, my lord.
My lord, we have posted also, my lord. There is acknowledgement in there.
Posted, you give us copy. This is not the
Complaints of its affidavit also given, my lord.
Show us.
It is, I have filed in that, my lord. There is
Not
signature.
filed. On which date it is filed?
Okay.
You must have your copy, office, your.
There is office copy.
This is not endorsement.
18/7/2024.
Dated?
There on.
You find out put your house in order. 15th December, 15th November. Yes. Next.
There was a civil litigation between 1993 to 2017 as to whether the property for which I am claiming is part of the acquired property or not. The matter went up to the Supreme Court in 2017 Supreme Court said that this is part of the acquired property. 2020, I filed the writ petition seeking quashing the acquisition proceedings only on one ground. Physically, it is part of the acquired land. Legally, it is not a part of the acquired land because neither there is a 4-1 notification, nor there is a 6-1 notification, neither is there a section 9 notice or a 12-2 notice, so far as the petitioner is concerned. That is the appellant before your lordships. Now, the learned single judge only dismisses on the ground of delay and laches.
Delay.
Delay and laches because from 93 to 2017, the list was pending before the civil court, which went up to the Supreme Court. Only on the point as to whether or not this is part of the acquired property or not, physically. This notice is not yet ordered, minutes. Notice is not yet ordered in this writ petition, in the writ appeal.
My lord, the locus standi as well as delay, my lord. They have acquired the property subsequent to the acquisition, my lord.
But legally it is not acquired.
Learned single judge.
Lords, legally it is not acquired. There is no 4-1, there is no section 6-1, there is no 9 notice, there is no section 12-2 notice, there is no award in my name. It is only because the authority is physically squatting on the property, the lease has arisen. Para 23 minutes, the learned judge says that there is no whisper. As a matter of fact, all the judgments are produced. The first of the litigation arose in the year 1993, went up to the Supreme Court and decided in 2017.
Notification of 1978.
Lords, the notification though is of the year 1978. Lords, this property was never divested from us. We were in possession of the property. As a matter of fact, the revenue entries continues in our name even as on today.
Civil court decided
Lord, civil court only decided the issue.
holding the validity of acquisition.
Lords, the civil court,
By framing a specific issue. Evidence was led.
Lords, that is
And the-
physically.
The very land was held to be valid.
Lords, that's the reason why I said, Lords, the civil court did not,
Appeal was dismissed.
Lords, appeal was withdrawn. The reason why I'm submitting this is, Lords, the civil court returned a finding on the basis of the sketch furnished by them, saying that this is part of the sketch which is produced by them to show that this is part of the acquired property. But the contention which we raised before the learned single judge, Lords, which is apparently not considered by the orders of the learned single judge, is there is no 4-1 notification in my name, no section 6-1 notification, there is no section 9 notice, there is no award notice, there is no award passed in my name.
You can't raise it, dismissed.
Lords, may I just, there are some judgments, Lords, which I wanted, because it's squarely covered, Lords, by some of the judgments which the Supreme Court has taken a view. That so far as the property, Lords, now a situation, your Lords will consider this.
Apart from delay, the finding is that your.
Lords,
other-
the delay,
22 also. ma'am.
Lords, delay is concerned, Lords may kindly
No,
take, Lords,
apart
the,
from delay, the finding is that your mother pursued is after the.
Lords,
Para
no,
22,
that is the
ma'am.
reason
Para
why I said,
22.
Lords, if a finding was recorded that this land is duly acquired by publishing a notification under section 4161 and there is an award in my name, in the name of my vendor, Lords, certainly I would not have had any case. There is no such finding. And factually, my Lords, it cannot be disputed that there is no 4161 or award passed in my name. Now property is gone, neither the compensation nor the land. This scenario, my Lords, cannot arise. And whatever compensation they claim, they say, my Lords, is subject matter of these proceedings is already disbursed to various parties. Matter requires a little consideration, Lords. My property rights is, Lords, now I have been agitating before the civil court from 93 to 2017. I went even before the Supreme Court, Lords. The Supreme Court, Lords, ultimately held that physically it is shown that it is part of the acquired property. But the only question which I am raising, Lords, even at your Lordship's hands, is that if there is no legal document to show that my property has been acquired in a manner known to law, question of delay and laches will not come. That's the precise question which was answered, Lords, in 3 judgments of the Honorable Supreme Court at least. May I just refer to those 3 judgments, Lords. Precisely the same question was considered.
Very good judgment.
Please. Lords, the first of the judgment, Lords, is Basnet's case.
In 71, the acquisition was.
Lords, here also in Basnet's case also, it was 1971. It was challenged after 20 years. The Supreme Court says, if the state is not in a position to establish.
The decree is passed.
Lords,
Following the validity of.
Lords, the decree was in our favor, Lords. What happened? Lords, I'll just point out, Lords. The decree which was passed by the civil court in the second instance in a suit for declaration on possession was in our favor. Para 13 onwards, Lords, in Basnet's case. Lords, the facts of this case is more or less the similar facts, Lords, as is presented in the present case. Lords, here in a worse situation is that in this case, there was no civil dispute. We were gone before a civil dispute disputing that this property was not subject matter of the physically acquired land. Para 13 minutes. That brings us to the question whether the process of acquisition has been followed in accordance with law. No notification has been shown to us of the intent to acquire the land under Section 4 or any other declaration thereafter. In fact, what is claimed before us, also before the courts below, is that no records are available in respect to the acquisition process. This obviously puts the respondent state in a difficult situation, which was sought to be got over by only relying upon a consent having been obtained for acquisition and the compensation having been paid as determined. On the aspect of compensation by a covering letter dated so and so. Lords, I'll skip this only to indicate the facts. Lords, may then kindly come, Lords, to the next page, para 14. We may note that even though the rights in land is no more a fundamental right, still it remains a constitutional right under Article 308 of the Constitution of India. Provisions of any act seeking to divest any person from the rights have to be strictly followed.
It's settled law that procedure under section 4(1) under akin to 5(1) of the Act is mandatory, and unless that notice is given in accordance with the provisions contained therein, entire acquisition proceedings will have to be vitiated. An entry into the premises based on such non-compliance would result in an entry being unlawful. The law being expropriatory in character, the same is required to be strictly followed. The purpose of the notice to intimate the interested persons about the intent to acquire the land. These provisions as they read as the said Act thus requires to be followed. We find a detailed discussion about the law as evolved and the rationale in the case of Vidya Devi. The appellant was forcibly expropriated from the property, so on and so forth. In this, the question of limitation is considered. At page number, by referring to Tukaram Kanajoshi at 12.14, para 17. Para 17 minutes on the question of delay and latches.
Third learned senior advocate, Mr. Ravi Shankar, assisted by learned advocate, so and so for the appellant, and learned additional government advocate, Mr. Harish, for the respondent, who appeared to assist the court upon service of the copy of the appeal in advance. The present appeal, at the instance of original petitioner, filed under section 4 of the Karnataka High Court Act 1961, is directed against judgment and order dated 12th December 23 of law in a single judge, whereby the writ petition of the appellant came to be dismissed. Full stop. In the petition paragraph, in the writ petition, the prayer was to direct the respondents, the prayer was to declare that the act of the respondents in taking possession of the property described as block number 9, revenue survey number 4 of Chakur Plantation, Yelahanka Hobli, Bengaluru North Taluka, had measuring 2 acres and 20 guthas without paying compensation to the petitioner as illegal. The second part of the prayer was to grant declaration that the entire acquisition proceedings in respect of the said land was not legal. The third prayer was to declare that the petitioner was entitled to possession of the said property, as the acquisition was bad in law. The case paragraph put forward in the writ petition was inter-alia that the mother of the petitioner, Srimati Saroj Gupta, purchased the property in question from one Sri K. Rangappa, following which the said land came to be bequeathed to the petitioner by way of registered will dated 10/1/16. After the death of said Srimati Saroj Gupta, 2 notifications dated 4/11/71 and 20/12/78 came to be issued by the authorities acquiring the said land belonging to the petitioner. It is the say of the petitioner that said notifications contained the name of Sri Rangappa.
It did not contain minutes.
That is what your case.
No, that's essentially the only case which I have put forth. That's the reason I am submitting.
I'm only dictating from your pleadings.
No, minutes. Kindly have a look at that.
You
Never.
go to page 63.
Pardon, minutes. Page 60. My apologies. It's not minutes. I have produced the notifications.
All right. Neither did not mention the name of said Rangappa. The award of the land acquisition officer was published on 18/1/80.
Award is also in the name of notified khatedars, not Rangappa.
The award dated 18/1/80 was passed in respect of second acquisition, contained the name of Sri Rangappa for the first time as Anubhavdar. This is what you stated.
Yes, minutes.
Yes.
But the award is in the name of the notified khatedars. Minutes, I have produced the award at annexure H2 minutes. That's the reason why I said, minutes, if an award is made in my name, that will be followed by a section 12(2) notice. Not, there is only reference to one sentence, my lords, in the entire award saying that Rangappa is the Anbavdar. He is neither the notified Khatadar in 4.1 nor the notified Khatadar in 6.1. Notes, one single sentence is found, he is the Anbavdar. Award is not passed in his name. Notes, I'm taking a very specific stand, notes, which I have stated. It specifically says, the said award depicts the name of Narayanappa, Sriharsha, Dodbuniappa, Birapan, Doddamma as the Khatidars. Award is made in their names, they have taken the compensations. Notes, now, the physical existence of my land is not in dispute. The fact that they have taken over my property is not in dispute. I am not paid any compensation. That is essentially, my lords, the relief which I had sought for at the hands of the learned single judge. My land, my lords, ultimately it will not vanish into thin air. My land. I had proprietary rights, my lords, over this property. At least they had to take a stand, my lords, as to whether this award amount at least was disbursed or not. Even that stand was not taken by the government. Lords, whether 19(1)(f) is there or not, 300A at least assures me, my lord, that unless compensation is paid, my land cannot be taken away.
I thought that arguments were over, therefore I started judgment.
Lords, my apologies.
You thought that the judgment is never started, so you started interrupting.
Sorry, my lords, my apologies.
Dismissed. You'll receive the order day after.
My sincere apologies, my lords. I did not intend to interrupt, my lords, with your lordship's declarations. My sincere apologies. My apologies, my lords.
So there is one more aspect.
Lordships.
It's a foolproof case against you, Mr. Otherwise,
I thought it the other way around.
amount has been deposited. Page 36.
Yes. Please.
Next.
So number 20 to PM Nair.
Yes, what is it?
My lord, the absorption rules, my lord.
Pardon?
Absorption rules, Annex A, my lord, deprives the appellant from the availing the pension, my lord. Page 32, my lord. Lord, that was the constitutional validity was challenged before the dishonorable court, my lord. The learned single thing, my lord, on the petition estoppel and delay. My lord, earlier, my lord, this pension proposal was proposed, my lord, recommended. Page 31, my lord, by the controlling authority. My lord, then, my lord, the third respondent.
In this matter, instead of you arguing, we may argue. Go to page 15. And read rule 4.2.
Lord, what happened is during the pendency, my lord, restricted the prayer for the purpose of pension, my lord. Page 88, my lord.
We adopt a reverse process. After we argue, then you argue. If at all, you can argue. 4.42, you read it.
Page, my lord.
Page 15.
The service rendered by the persons absorbed under.
Services rendered by the persons absorbed under these rules prior to the commencement of the scheme. Commencement of these rules shall not count for the purpose of leave, pay, pension, seniority, and grant of promotion.
The
Time-bound advancement scheme for grant of selection time grade on pay. Now look at your prayer. Prayer is exactly contrary to this rule.
Lord, that prayer I have restricted to purpose page.
Exactly contrary to rule, you want to count the services prior to this coming to force for the purpose of your pension.
Yes, my lord. This is the.
You retired in 2005 and this
petition. 2012, my lord.
Petition was filed in 2024. What?
My lord, before that, my lord, this petition was before this honorable court, my lord. Annexure F, my lord. This honorable court directed the first respondent to consider the representation, my lord. Annexure F, my lord. On this honorable court directed the first respondent. Then, my lord, the respondent was not considered, my lord. Annexure H, my lord.
issued on during 2016, my lord, quoting the rule, my lord. My lord, then, my lord, this appellant preferred the writ petition challenging the constitutional validity, my lord, because pension was deprived, my lord. He is not related to other benefits, my lord. He is only asking about his pension, my lord. To consider because Rule 224B of the Karnataka Civil Service Rules provides for the considering of the earlier service, my lord.
Sorry.
Number 21. The person aware.
No, the learned single judge will not allow the writ petition.
7 to 19. Oh, 20. Yes.
But learned single judge allowed the writ petition filed by the fourth respondent on the ground that not the assistant commissioner and deputy commissioner have decided the title of the appellants while dealing with the appeal under section 136(2) of the Karnataka Land Revenue Act and revision filed by the fourth respondent, assailing the correctness of the order of the assistant commissioner under section 136(3). But in the order impugned, lords, before the learned single judge, the title has not been decided. Only the mutation was questioned. Mutation was effected, lords, without notice to the appellants, lords, by in favor of the fourth respondent. That was called in question by the appellants before the assistant commissioner. Assistant commissioner, lord, pursuant to the order of the land tribunal, lord, mutated the name of the appellants, which has been challenged by the fourth respondent before the deputy commissioner. Kindly see, my lords, annexure J, my lords, order of the deputy commissioner for a moment. Lord, there is no title dispute was, my lord, raised before the deputy commissioner. Para number 13, page number 167, my lords, of annexure J, my lords. $167 minutes.
This lease agreement is registered. Okay?
My lord, registered lease agreement was there, my lords, because my lord, the producer of the appellants, my lords, filed a suit for bare injunction, where, my lords, it was suggested to go for lease, assuming that, my lords, these lands were acquired. Acquisition of land, my lords, with respect to survey number 13 and 14, whereas, my lords, the lands in possession of the petition appellants, my lords, was survey number 17, 1, 4, and 5, which out of which, my lords, 2 items were conferred by the land tribunal in the year 1982, wide annexure R8, my lords, whereas 1 item, my lords, purchased by the producer of the appellants, my lords, from by virtue of sale deed, my lords. Under the mistaken notion, my lords, since the suit is for bare injunction, the illiterate villager, my lord, was forced to agree for registered lease, my lords. However, it was for initially 5 years, then it was extended another 2 years, then it was not extended. Then, my lord, a suit came to be filed. The suit was dismissed on the mistaken notion that, my lords, the land is acquired. My lord, R12, your lords, may kindly see, my lords, the very assistant commissioner himself, my lord, issued an endorsement stating that survey number 17 is not acquired. R12, my lord, is page number 304, my lords, translated page number 306, my lords. The order of the land tribunal and as well as the endorsement issued by the assistant commissioner has been relied upon by the deputy commissioner while passing the order, rejecting the revision petition under 136(3) filed by the fourth respondent.
Where is the order impugned in the petition page?
Lord, writ petition, Lord, annexure J, my lords.
Page.
Lord, which commences from page number 157. Lord, relevant page, my lords, para number 13, 167, my lords. Para number 13, page number 167.
Operative portion,
Please.
168.
One para, my lords, para number 13 may be relevant. The respondents filed an appeal before the Assistant Commissioner Shivamogga against the endorsement issued by Tahsildar, along with an IA and affidavit requesting to condone the delay in filing the appeal. As seen, the endorsement issued by the Land Acquisition Officer Vide so-and-so dated 28/4/1995 clarified that the land in survey number 17 of so-and-so village has not been acquired under the land acquisition proceedings. The father of the respondent number 3 to 9 had never sold the disputed land in favor of the revision petitioner, and the CMC has not acquired the title and ownership of the land measuring 3.18 guntas of land in survey number 17/1, 17/4, and 17/5 of Urgadur village by means known to law. The land under dispute is a granted land by the land tribunal, Shivamogga, under the provisions of Inam Abolition Act. Therefore, the Assistant Commissioner ought to have allowed the appeal filed by the respondent number 3 to 9, and thereby should have set aside the MR number 85/2004-5, since the orders passed by the land tribunal is final and binding. After the death of lessee, the right of the lease seized under the provisions of the Transfer of Property Act. The municipal corporation has not acquired any right in the disputed land. From the points discussed above, I proceed to pass the following.
You have failed in the civil suit also. Then you approach the revenue authorities. Get your name mutated, and the entries are mutated. How can it be done?
Civil court initial suit was bare injunction. Subsequently, lease agreement was entered into. That was expired. Then, my lords, one more suit.
What was the suit for?
Initial suit for bare injunction was. Subsequently, a declaration suit came to be filed. That was dismissed as withdrawn. And not subsequently, not when.
Your suit.
Yes, my suit. Predecessor of the appellants.
Where, what was the prayer?
Declaring that the plaintiff was the owner in possession of the property.
But that was dispute.
As a matter of fact, acquired land is altogether different. That was noticed at a later point of time.
That's right, but there is suit for title was dispute, and though dismissed.
Of course,
on what basis your mutation can be sustained?
Mutation is based on the intermean laws. An occupancy right has been conferred in the name of predecessor of the appellants. Therefore, that order has not been essayed by the department or fourth respondent. May I make one submission? There is no corresponding document to show that these properties are part of survey number 13 and 14. No, there were 3 suits, Lords.
We'll take up on Monday. Just assist.
Please.
Some clarity is required.
Please.
There were 3 suits, Lords.
Lord,
Initial
Lordship,
suit for.
We'll just go.
Lordship may issue notice to the authority, my lord. This land was acquired for the benefit of Bhadravati Shivamogga Development Authority.
That is the point, that acquisition record is not available.
Please.
If it is acquired, that is the basis, but
The land was acquired, my lord. They had taken the property on lease from the authority.
There is no record available about acquisition. That is where somewhere it is observed.
I understand.
Not if they show that these lands are part of the acquired land, not I am out of the court, not.
Monday.
Otherwise, not.
Admitted fact is that they claim to be lessee under the authority, my lord, the local body. They claim to be the
lessee of the local body.
under the local body, my lord. Who is respondent number 4 before your lordship?
Appellant.
Please, my lord, the revenue entries are directed to be restored in the name of the board, my lord, the corporation. So they were the beneficiaries under the acquisition proceedings.
So there is a lease deed in his favor.
Yes, it
But
was
they
a
are the
registered lease,
lessee
not, that
under
was
the
not
board.
extended subsequently.
You are a lessee.
Lessee,
You
my
can't
lord.
claim KYC.
That was,
the less.
Lord, initially, Lord, I filed a suit for injunction. Lord, during the pendency of the injunction,
Are you claiming title?
Lord, now, Lord, I am claiming title, Lord.
Page 30 may kindly be seen, my lord. There's a
Or let
finding.
me consider on 2:30 at Monday, on Monday.
Please.
Please.
Monday.
Please.
Silver.
That is kept for orders. We are keeping it on. That PF band
Yes, my lord.
is for orders. When it is kept. I told him.
Needs to be heard, I think. With regard to BBMP case 93.
Sorry, your lordship had directed us to file the synopsis. Mr. Naganand appeal. Yes, ma'am. We are aware. It will go to when I told him the reason. It is still not dictated, so therefore.
We have filed the synopsis also, Madam. Lordship had directed us to file synopsis, we have filed it.
All right. Keep it on 22nd.
Okay.
Number 22.
22, my lords, lords kindly, lordships had heard the matter and lord directed us to file synopsis. This matter pertains to non-payment of electoral work we had done. Lord, the synopsis is ready, Lord, we are filing it.
They have just served on me, my lord, just now, my lord. May I request your lordship to kindly have it next week, my lord? I'll go through the synopsis and also
This is that
disputed invoices, my lord.
payment.
Payment
Electoral
under the disputed invoices, my lord. May I request your lordship to kindly have it anytime next week, my lord? I'll go through their synopsis and respond to it. Grateful.
20th.
20th.
Please.
Number 23. Mr. Srikanth MP.
For appellant notes, there is a delay of 210 days, my lords.
Notice.
My lords, in fact, my lords, the counsels who appeared before the learned single judge informed me, my lords, they will take notice for respective private parties, my lords. So
Notice returnable on 29th of November. Will be open for counsel for the appellant to serve copy to the advocates who appeared
Please.
before learned single judge, in addition to normal. In addition to effecting service by normal mode.
Please.
Number 24. Is Sunita Srinivas.
Lord, I appear for the appellant in this matter. There is a delay application for 19 days.
However, my request in this regard,
Any other party, then government is there.
Private parties are there.
Then notice returnable on
my lord, my only
3rd
request is
December.
the impugned order imposes a time limit for the remand of 30 days. That 30-day period ends on 29/11.
What can be done if there is a delay?
Let them not precipitate the matter because we have been asked to, my lord, it will be rendered in.
Therefore, we ask that any other party is there who are
Yes,
required
yes.
not to record, if any party is not required to be served, then we can condone the delay. So there are private parties.
There are 2 private parties with the employees.
We can give early date at the most,
My lord, next week sometime.
25th of November.
My lord, 29th is the date that 30-day period expires.
So we are 25th here.
My lord, they've already said you lose your opportunity to file any written submissions. Just in order not to precipitate the matter.
You
my
may
lord.
be justified in your own way, in your own way, but when there is a delay, we can't.
My lord, it's only
Granted.
19 days. If I may make that one submission.
What is this? What is urgency? What is urgency?
My lord, in this regard, on 29th of October, the 4th respondent had directed us to file our written submissions in this regard. We are not an industry under Section 2J of the Industrial Disputes Act. The conciliation proceedings were initially closed. The learned single judge set aside that order.
There is no urgency. Even then 25th of November, sir.
So, commercial appeals, seal number 25. Appellant YP.
Is the appeal for the respondents, my lords. Respondents, my lords.
This is a matter where the respondent participated in the bid to supply 5,000 metric tons of de-oiled
This is
rice.
first, this is commercial appeal,
Please,
money decree. Will issue notice if you want to stay, deposit the amount.
I'm ready to deposit. I am ready to deposit.
You made the deposit.
I'm ready to do it.
Ready to deposit. Heard, learned, advocate, and so and so and so. Notice returnable on.
Notice is already issued. They
No, it is
entered
okay.
caveat election.
I am representing the respondents, my lords.
You are appearing for caveat. All.
Yes, my lords. And I have already filed my statement of objections and documents, my lords.
So we may hear it final.
Please.
Heard, learned,
Yes, my lords.
so and so,
Worship,
so.
I'm ready to deposit. They are pressing for execution of the decree.
For the appellant and learned advocate, Mr. So and so, who appeared on online by virtue of caveat application filed. The present commercial appeal is, commercial appeal arises out of judgment and decree dated 11th June 24 passed by 87th, learned 87th Additional City Civil and Sessions Judge, Bengaluru City, Bengaluru in commercial original suit number 13 of 22. The suit of the plaintiff dash respondent herein came to be decreed, paragraph. Decreed with cost, decreed holding the plaintiff entitled to recover rupees 10,40,000 with interest at 12% from the date of the institution of suit till realization. And the defendant was directed to pay the said amount. Full stop. In the effects of the case, appeal is admitted. Learned advocate for the appellant, prayed for stay of the judgment and decree. The judgment and the decree being in the nature of money decree, without imposition of condition of deposit of the amount, the stay cannot be granted. In that view, paragraph. Stay of between judgment and decree during the pendency of the appeal on condition, however, that the appellant deposits the decretal amount, entire decretal amount, together with interest till date within 6 weeks, please, 6 weeks from today, full stop, before the registry of this court. Once the amount is deposited, the registry shall list the appeal before the court for further appropriate orders.
Madam, records may be.
Notice of admission shall go to respondent to.
Records may be called for trial court records.
Record automatically doesn't come once the appeal is admitted. What is the procedure here?
We'll have to.
It will
check.
automatically.
No, it's not automatic. We have
Not
to, we have to pass an order.
In first
Automatic.
appeal, in first appeal, the record doesn't come automatically. Record in proceedings shall be called for from the court so as to read this court within 8 weeks.
Serial number 24. This is an inconvenience for 25th. May we have it on 26th?
26, 20.
Number 27, say arbitration matter, then it's first appeal.
I appear
My
for the
lord, I appear
appellant in
for the
this
respondent
matter,
number 1, my lord.
My lords, the appellant
My
is.
lord,
new
other-
for-
Otherwise, the otherwise the appeal was filed within 120 days
Please, my lords.
and 29 days delay. What is the explanation?
My lords,
My lord.
confusion with regard to jurisdiction, my lords. The seat of arbitration was supposed to be Mangalore. However, my lords, that fact was not brought to the notice of this honorable court while passing an order in CMP. Arbitrator respondent number 2 and the bench of arbitration was Bangalore. Thereafter, my lords, we did not know if we have to file it in
My lord,
Bangalore.
my
or
lord,
in
one
Bangalore.
submission, my lord.
Notice for final disposal.
My lord.
Returnable on.
My lord, one submission, my lord. They have filed an MFA before this honorable court, my lord,
Clear you, notice for
which is
final
not maintainable, my lord. They are supposed to file a commercial appeal, my lord, not an MFA. It has come under an MFA. It is a commercial court, my lord. The trial court is a commercial court. And the 34 application was filed before the commercial court, Mangalore. So it should be a commercial appeal before this honorable court and not an MFA.
This is treated as commercial appeal.
But my lord, it is MFA, my lord. That is what the cost title says.
Right, that it is MF, but it has come before the commercial court.
But my lord, the classification says that it is MFA.
Arbitration application.
And the cost title also does not talk about section 737, my lord.
The new arbitration matter comes here as commercial matter.
My lord, the classification comes as commercial appeal, my lord, not as minister's first appeal, my lord.
But nevertheless, it will come before this bench only.
Please, my lord.
That is correct. Official examine the nomenclature of the present proceedings.
Let's,
Submit a report to the court on 23rd of.
My lord, it is not maintainable as MFA, my lord. It can be maintainable when it is commercial appeal.
In any case, it will come before this court or no?
Please, my lord.
my lords, one request, my lords. I've sought for stay of the operation of the impugned order, my lords. Execution has been filed by the respondent. It is listed tomorrow itself, my lords, before the trial court. We've already deposited 20% of the award amount before the trial court, my lords, when it was granted
And
there.
today it is, we are concerned with the condonation of delay order on.
No, it's condonation of delay of the original proceedings, my lords. Before this court, there is no delay.
The delays refuse to be condoned on.
Please, my lords.
That is why you are here.
Please, my lords.
That is what you are saying. You are here against the non-condonation of delay.
Please, my lords.
So first you have to cross that hurdle.
That's,
So therefore we are asking that what are the cause for delay? What are the reason for delay?
my lords, confusion is the only reason that has been stated in the affidavit, my lords.
My lord, every day, my lord, the law officers from the Port Authority appear before the trial court. And they cannot plead that there was a confusion.
Just find out, put up tomorrow. Tomorrow will pass.
Please, my lords.
No. He is saying that according to so what should be nomenclature?
Commercial appeal, my lord, commercial appeal.
Plan. It doesn't appear to be so. This is rising out of arbitration process.
Please, my
No, my lord, arbitration proceeding before a designated commercial court, my lord.
Just will permit the nomenclature to be changed.
Please.
If it is maintainable here only, then there is very question of nomenclature. If it is not maintainable before this court, then you will be
Please,
right.
it is maintained.
Just fine. Tomorrow at 11.
please.
So find out and give me.
Number 28,
Appearing for the respondents.
complaints in contempt matters.
Lords, IA 3 of 24 for substituting, my lords, the present incumbent, my lords, as an accused, my lords.
as is
Pardon?
My
A
lord,
3 of 20.
we have filed our compliance. However, my lord, my preliminary objection would be on the delay. There is a delay of more than 3 years. And in fact, there's an IA for condonation of delay, which is 632 days they mentioned. The impugned order over here, my
There
lord,
is no delay in contempt matter, either maintainable or not maintainable.
it's not maintainable because of the delay.
My lords,
That's
it
it.
is not.
There is,
And I would like to, please, my lord,
there is no delay. It is barred.
it's barred.
Correct.
Exactly.
I'm
My
afraid
lord,
it is not,
that-
my lords, we
So-
have stated.
So she appears to be right, order of 2020. And the,
Let me submit this, my lords.
And in fact, here, my lord, there's a checkered history. The complainant herein has challenged the governing council order, which is part of a stay proceedings, which I've mentioned in my compliance affidavit. Having filed the compliance affidavit, that is one side of the matter. On a factual matrix of the case with regard to delay, my lord, it needs to be dismissed. With cost also, because I would like to rely on this particular judgment, the recent judgment of the Supreme Court in 2024, my lord.
I believe, my lord, it is my case. Let me make
No,
some.
but it's about the preliminary objection.
Yes,
of
I
delay.
have to, my lords, I have to say why my case has to be considered. My lords, I should have the opportunity to substantiate my stand.
pardon?
I should have the my lords, opportunity to substantiate my stand, my lord, is what
Yes,
I
yes.
said.
Yes.
Instead of my lords, my learned friend objected to it. Okay.
Uh,
No, we will not look into it.
Please.
Until the council argues.
Please, my lord, the issue
I
is
will
this.
give my copy to the council.
My lord, the issue is this. I was before the learned single judge of this honorable court, my lord, saying that I should have been retrospectively absorbed. Writ petition is dismissed. I come before the division bench, my lords, filing a writ appeal. An order is passed by the division bench, setting aside my lord's absorption. Also observing that the authorities will not look into the affidavit which is said to have been filed by me, seeking for absorption from a prospective date, and it was stated it will be considered afresh. An endorsement is issued by the state saying that yes, you are absorbed subsequent to the order of the division bench. Will inform you about the date from which it is given effect to. Thereafter, my lords, they don't, my lords, intimate me anything. However, my lords, it is placed before the governing council of the institute, Nephrology Institute. There a decision is taken to place the matter before the vice chairman. Vice chairman says absorption is confirmed, approved by not the chairman, who is also the honorable chief minister. They don't, my lords, issue the order indicating the date. It is kept as it is. I suffer an order, my lords, before a learned single judge, where a seniority issue is raised by another candidate of my lord, the institute. I have filed an appeal. My lords, in those circumstances, if your lordships kindly see the last order, my lords, passed by this honorable court. It was, my lords, observing that a writ appeal is pending. And it was thought fit that, my lord, the matter may be posted after, my lord, the date. That writ appeal, my lords, is being listed on Monday. Monday, my lord, the writ appeal is being listed before this honorable court, where, my lords, I have challenged the order of the learned single judge, where, my lords, intentionally this accused and, my lords, the director of the institute, they don't bring to the notice of, my lords, the court about, my lord, the decision to absorb me in services. It is their fault that they have not issued the order. My lords, the cause of action, my lords, is, my lords, they are recurring alive even to this day. They cannot plead, my lords, delay on their part. My lords are saying that there is delay, it is to be, my lords are dismissed.
Why?
Please. Last order, if your lordships kindly see, my lords. Last order in this, last order in contempt petition, this contempt petition.
What is that order?
Your lordships indicated that, my lords, the writ appeal, which is pending before, my lords, a coordinate bench.
No, writ appeal is separate proceedings.
Yes, my lords, I would.
The contempt is barred by limited.
Yes, my lord, that is, my lords, that is what I am trying to say. My lord, according to me, my lords, the cause of action, my lords,
is still there, alive.
How?
My lords, your lords may kindly have a look at, my lords, the order of the learned single judge. Order of the division bench of this honorable court, my lords, if it is seen, of which, my lord, the contempt is alleged of.
Since you challenged,
I have not challenged.
who has said?
No one has challenged. It has become final. In fact, my lords, I have filed, my lords, rejoinder, my lords, affidavit also, saying that, my lords, what transpired, my lords, after the order of the division bench. If your lordships, lords, have the order of the division bench, my lords, for a moment. Annexure A.
So what you are relying on from the?
My lord, my first submission, if my lord and friend has finished, my first submission, if I look into section 20 of the Contempt of Court Act,
That we know what.
it's a negative section. It says no court can entertain if it is beyond 1 year. Therefore, I rely on my first submission with the preliminary objection of the citation that I've forwarded. Para 45, my lord, which speaks about of the decision that I just put forth, which is Tirupati Rao versus Lingam Maya. This speaks about the entire scope of section 20 and as to how section 20 came about. At para 44, if I, in upholding the virus of section 20, my lord, it looked into, there was a joint select committee of the parliament on contempt of court, Bhargava committee, after examining the report of Sanyal committee on the question of limitation, though the contempt procedures by their very nature should be initiated and dealt with as early as possible and considered it necessary and desirable that the period of limitation should be specified in respect of actions for contempt, therefore laid down the new clause, clause 20, a period of 1 year at the expiration of which no proceedings for contempt should be initiated. The reasons given by the joint committee for introducing clause 20 in the bill as reported by it are these. The committee are of the opinion that the contempt procedures are their very nature should be initiated and dealt with as early as possible. And it was brought to the notice of the committee that in some cases contempt proceedings have been initiated long after the alleged contempt had taken place. The committee therefore considered it necessary and desirable that a period of limitation should be specified in respect of actions for contempt and have accordingly laid down the new clause for a period of 1 year at the expiration of which no proceedings for contempt should be initiated. Now, that was the object and the scope and the reason behind bringing about section 20. Then we look into para 54, my lord, of the same judgment. 54 of the judgment speaks about action for contempt. Though instituted through a petition or an application is necessarily in nature the original proceeding, so and so, a prayer for condonation of delay in representing the petition application alleging contempt would not be maintainable. The express negative phraseology used in section 20 of the Act as legislative injunction places a fetter on the court's part to initiate proceedings for contempt unless the petition application is presented within the time frame stipulated therein. However, since section 20 also uses the expression date on which the contempt is alleged to be committed, as starting from the point of the period of 1 year to be counted for reckoning whether the petition application has been presented within the stipulated time. The High Courts ought to be wary of the crafty and skillful drafting of petitions and application to overcome the delay in presentation thereof. Now, para 56, my lord. Para 56 also goes on to saying, if I look, take your lordship, for continuing wrong, if there is a continuing wrong, where in the present case there is no continuing wrong, to be accepted as a ground for seeking exemption in an action for contempt, the party petitioning the court not only has to comprehend what the phrase actually means, but would also be required to show from his pleadings and the ground resting thereon, he seeks the exemption for limitation. Should the party fail to satisfy the court, the petition is liable to outrightly be rejected. Also, the court has to be vigilant. Stale claims of contempt, camouflaged as continuing wrong, breach, offense, ought not to be entertained, having regard to the legislative intent for introducing Section 20 of the Act, which has been noticed above. Contempt being a personal action directed against a particular person alleged to have committed contempt, much of the efficacy of the proceedings would be lost by passage of time. Even if a contempt is committed and within a stipulated period of 1 year from such commission, no action is brought before the court on the specious grounds, commission, no action is brought before the court on specious ground that the contempt has been continuing, no party should be encouraged to wait indefinitely to choose his own time to approach the court. If the bogey of continuing wrong, breach, or offense is mechanically accepted whenever it is advanced on the ground of claiming exemption, an applicant may knock the doors of the court at any time suiting his convenience. If an action for contempt is brought belatedly, say any time after the initial period of limitation and years after the date of the first breach, it is the prestige of the court that would seem to become a casualty during the period of the breach continues. Once the dignity of the court is lowered in the eyes of the public, non-compliance of its order, it would be farcical to suddenly initiate proceedings after a long lapse of time. Not only would the delay militate against the legislative intent inserted in Section 20 of the Act, so on and so forth. Then finally, my lord, in this case, at para 80.
In what way, in what way it is all alive?
Your lordship, my lords, I tried to, in fact, meet this contention in my rejoined lords, which I have filed already. Your lord, if your lordships kindly take lords, page number 18 lords of the rejoinder. I have stated so, my lords. What happens is, my lords, it's like, my lord, first I'll try to, my lords, demonstrate from the order of the adjournment of the Zonal Court. Page number 20, my lords, of the contempt petition. My lord, specifically, my lords, relief which was granted at small Roman 5 minutes. We direct the state government to consider the case of the appellant for absorption in the cadre of assistant professor in accordance with law as expeditiously as possible. The decision shall be taken by the state government not later than 1 month from today, which shall be communicated to the appellant. My lord, specific directions issued on, my lords, writ appeal, disposed of, my lords, on 28th February 2020. My lords, admitted fact. After this, if your lordships kindly have my rejoined, my lords, which I have filed. How there is, my lords, deliberately there is an effort on the part of, my lord, the respondent state to show as if that they have complied with, but they have not complied with the order of the learned single judge. If your lordship kindly have, my lords, annexure D at page number 21, my lords. 24, my lords, is the English translation. They state, my lords, clearly that there is absorption in pursuance of the order on writ appeal. Separate order will be passed after holding the governing council meeting. That's an assurance given saying that we have absorbed. That is, my lords, as on 12/5/2020. Lords, within a very short period from the date of disposal of my lords, the writ appeal. They don't do anything, my lords, after that. Then matter is placed before, my lords, the institute, that is governing council of the institute. On, my lords, 24/1/2022, the issue is brought before the governing council. The governing council, my lords, is apprised about the issue. Governing council Governing council says, as per rules, there is no retrospective absorption, but let the matter be placed before the vice chairman, who happens to be, my lords, the honorable minister for medical education. Matter is placed before him. He says absorption is confirmed. He says issue orders. Honorable chief minister also approves. That is, my lords, in 2022. They don't do anything, my lords, after that. That is, my lords, the accused, who is, my lords, the principal secretary, who is required to pass the orders. Nothing is done. No, it is not communicated, my lords, as directed. My lords, one of the person, my lords, who is seeking for seniority, my lords, as I was considered to be senior, he approaches this honorable court by filing, my lords, writ petition at page number 40, my lords, if your lordships kindly see. WP 23876 of 2022. Though, my lords, it is specifically stated earlier that I have been absorbed, but orders will be passed subsequently. And the institute being a party, the government being a party, my lord, government does not say anything, my lords, before the learned single judge about the absorption and what are the facts which transpired later on. They keep quiet. I suffer an order. In fact, the learned single judge, my lord, goes to the extent of saying, I was not even absorbed. State, my lords, in spite of saying that the decision is taken to absorb, my lords, keeps quiet. In fact, I am before the division bench of this honorable court by filing an appeal which is listed on Monday, where I am contesting. My lords, I also, my lord, seek for issuance of specific orders, as stated by, my lords, the division bench of this honorable court, where I am required to be communicated, my lords, where they say they have held, they have taken a decision. That writ petition is pending. When that is pending, there is an interim order. It was brought to the notice of the learned single judge there that an effort is made to repatriate me, my lords, to saying that I do not belong to that, my lord, the institute. Again, clandestinely, my lord, suppressing all the pending, my lords, litigations. A resolution is passed, only citing, my lord, the order of the learned single judge, saying that I am not absorbed. My lords, continuously there is suppression of fact, my lords, at the hands of, my lord, the accused. It's not that, my lords, once, my lords, it was done or otherwise. My lord, this is going on, my lords, happening, my lords, throughout. In these circumstances, my lords, I have taken specific plea. If your lordships kindly see, my lords, my rejoined, I have, in fact, my lord, relied upon decisions of the Honorable Supreme Court also, my lord, to substantiate that. Paragraph, my lords, 25, my lords. It starts with, my lord, respectfully seeking kind leave, my lords. Lords. Of this honorable court, I bring to the notice of this honorable court and quote the observations of the Honorable Supreme Court of India in so and so. The law of contempt has been enacted to secure public respect and confidence in the judicial process. If such confidence is shaken or broken, the confidence of the common man in the institution of judicial and democratic setup is likely to be eroded, which, if not checked, is sure to be disastrous to the judiciary itself. Next, my lords, I rely upon, my lords, another edition in 2014 8 SCC, my lords, where it is observed that disobedience of orders of a court strike at the very root of rule of law on which the judicial system rests. judicial orders are bound to be obeyed at all costs. My lord, there are specific directions issued. In the pending proceedings also, there are directions issued, making it subject to, my lord, the result. And the court goes to the extent of saying that no order should be passed. In spite of that, my lord, they say that you have been repatriated. My lord, it's only to ensure that, my lord, one person, my lord, is favored. My lord, that contention I have taken, my lord, he was a party, my lord, in the other proceedings. My lords, when there is, my lords, I can understand, my lords, if any other authority, my lords, making any statements, private person, my lords, doing it. But, my lord, the government, my lords, indulging in, my lords, these kind of acts.
Will continue.
My lord,
Please.
I have
Tuesday
only
will continue.
Please.
3 submissions to make with regard to.
Tuesday, 2:30.
Okay.
Please.
Tuesday, 20.
May I make one submission? Make one submission, my lord. Serial number 38. What should the word this matter, my lord, last? Posted for today. The repeated arguments, my lord, the election commission was making arguments last week, my lord. Then due to time, my lord, it has been adjourned today.
Payment,
38, my lord, serial. number.
payment to.
No, my lord, the contempt, election matter, my lord, where
They were supposed to conduct the election, my lord, within 3 months from the date of the learned
Yes,
single judge's order.
that matter.
In serial number 43 also, my lord, with similar, the identical matter. And
yeah,
they were supposed,
38.
my lord, they were directed to file affidavit, my lord, in the month of September. Not even, my lord, till today, they have not shown.
It was heard, fully heard.
Yes, my lord. 38 was heard, not 43,
38 was heard, my lord, that.
not
so far as-
43, my lord.
So far as 43 is concerned, my lord, they were supposed to file an affidavit as per your lordship
Now we come
direction.
to 38, 30 was heard. Anybody wants to argue further?
Yes, my lord, we have not made our
Used,
submission.
we have not,
Election authority has-
election authority has not yet started, ma'am. They have to start.
Should may accommodate, my lord, tomorrow.
No,
No,
may not be. Next week, or
My lord.
a week thereafter.
No, please, Next madam. week, my lord.
There is no urgency. What is?
Next week, we have engaged the service of Professor Ravi Verma Kumar.
July, my
We have
lord,
engaged the service of Professor Ravi Verma Kumar, my lord. He will not be in station next week, day after next, please.
the directions issued, my lord, to conduct the election, my lord, in the month of July.
That is 43, don't confuse.
July. No, I'm making in the
38,
the
30,
identical questions it is.
38 is different,
19th,
19th.
19th,
My lord, can it be on 21st, my lord?
21st.
Please.
It's for 2:30.
Your lordships have already heard that matter.
Oh.
No, only they have made submission, not we even. State has to make their submission.
When do you want? 21st?
Please. 21st is, yes.
Let's see.
For 2:30,
Serial number 43 also, my lord, same.
lordships have awarded, my lord. It's
We'll
been
take
1
up.
year, my lord, they have not conducted anything.
Yes, ma'am.
Once we are keeping, we'll
Yes.
take up.
43 also, my lord, to me, taken up
It
together. my lord.
pertains to a different.
Different, they're different
society.
district, my lord, very same order, my
One
lord.
by one, yes, put up, fast, yes.
6, Lord, serial number 36. Serial number 56.
It will be, both will be listed,
Lord, serial number.
both will be listed together on 12th of December, yes.
36, Lord, serial number 36.
Item 51, your lordship. Demand raised by senior geologists. Because of this demand, your lordship, mining operations across the state have been on hold. If I could request any date the next 2 weeks.
13th December,
Lord, serial number 86.1 million.
first. 2nd December.
Lord, serial number 86.1 million. There is an order dated 18/4 where the respondents are directed to pay 4 crore rupees to the contempt complainants. So if the matter comes up a bit early, then they will be paid. The petitioners are hospitalized.
Take the dates.
My lord, serial number.
43 is concerned, my lord.
Serial number 43.
Next week. One after, we'll complete everybody. Yes.
Next week.
My lord,
Post next week, don't post.
Serial number 34 and 94, my lord. Next week, my lord. Serial number 84.
Whole date, 2nd December or 3rd December.
Serial number 84, my lord.
My lord, serial number.
Retired as my lord, 21/12/2017. Special benefits have not been released.
Get this.
Serial number 35, my lord. My impleading application is as respondent number 5, my lord. Petitioner has not filed any objections for that. My impleading application may be allowed.
On that day we'll allow.
43.
Make a submission, my lord.
43 is, my lord, similar to item number 38.
lords, it's
My
a
lord, only thing is, my lord, they were, after hearing for some time, my lord, they were supposed to file an affidavit as per your lordship has directed to file the affidavit.
My lords, there is a
Why
writ
they have not
petition
taken
in
any
which
steps,
they-
my lord, in respect of conducting elections?
They-
So July, my lord, the directions was issued. We have issued the contempt proceedings. After hearing for some time,
State
they have
has,
supposed, they have directed to file the affidavit, my lord. And last date, my lord, hearing, it was not reached, my lord. It is, my
The same date, 21st.
my lords may kindly take it up
it
on
may
the
be
last. week,
tagged
because-
along with that, madam.
My lords, in this matter, my lords, it is not connected with 38. The reason is there is a stay in a writ petition proceedings for which we have sought for extension before the,
Legal keeping on 21st,
Please.
not connecting.
it's not connected.
Not, we are not connecting.
Please, please.
May make a submission, my lord.
Much obliged.
May make a submission.
Commercial.
My lord, serial number 30, my lord.
It's a commercial appeal, my lord. Now execution is being filed and attachment of mobiles is being filed by the other side, my lord. Therefore, the agency is kindly have it on 81, my
You
lord.
can seek time there on the ground of pendency of appeal.
Serial number 37, my lord.
Second,
Now, at least.
My lord, serial number 30, my lord.
23rd.
My lord,
23rd now.
79.
serial number 30.
98, if I may make a mention, my lord.
Get the date, bro.
ಹೋಗ್ತಾ ಇದ್ದಾರೆ ಅವ್ರ ಪಕ್ಕ. ಈ ಗಾಟ್ ಅಪ್